Gentlemen, good morning. I'm very happy to welcome you at this conference, which is entitled The Evolution of the State and Rule of Law. This is organized by the Batory Foundation and the Helsinki Foundation for Human Rights. I'm very happy to be co-organizing this conference and welcome President Maciej Nowicki of the Helsinki Foundation, whom I'll be handing the microphone to in a moment. But before I do that, let me say a few words by way of opening this important event, which is important due to your presence, but also, I believe, because the takeaways of this conference will confirm that the intention was that it was well designed, and there was an event that took place over 5 years ago in another political context. We met in this very room. Many of you were present, and we were wondering how to restore rule of law. That conference led up to a publication, a book that described various concepts, and another more long-term product of that conference was the effort of the group of legal experts working with the foundation, who together drafted bills to salvage the Constitutional Tribunal, and I want to thank them, and I want to thank everybody taking part in the discussion, because the idea was for these concepts, these ideas, to enjoy the support of experts and society alike. And now I want to thank the minister, whom I want to welcome with us today, for making this draft more than a social initiative, for making it a political bill, a proposed piece of legislation that's still being deliberated upon, but it is an important vehicle for our discussion on the restoration of rule of law in Poland. It's over a year since the parliamentary elections that gave us a chance to carry out various ideas and concepts. We realize that we cannot treat that previous conference, restoration of rule of law, literally. Even then, it wasn't about going back to life as it was before 2015. Everything evolves, and these evolutions and the changes we've been observing will be the topic of our discussion today, as will all the achievements, everything that's been done over the last year, and the things that have not been done, and the obstacles we're still facing. Before I hand it over to President Maciej Nowicki, I want to thank those who made this conference possible. This conference will also be available to those following us online. This is available online, and I want to welcome everybody joining us. And this was made possible with the help of our media partners, Dziennik Gazeta Prawna and Oko Press, as well as our interpreters, our Polish Sign Language interpreters and our English interpreters. Our Polish Sign Language interpreters are Elżbieta Żurawska and Joanna Borycka, and the English language translation is being provided by Artur Zapołowski and Dominika Gajewska. Thank you very much for your assistance. And now President Maciej Nowicki already has a microphone, so there's no need for me to hand one over to him. Thank you very much, ladies and gentlemen. I want to welcome everybody. I want to welcome all our guests from abroad. We're very happy to have so many of you here today, that so many of you are interested in this conference. I want to thank the Batory Foundation for allowing us to revisit this topic a year after, from a new perspective, from the perspective of the experience of this year, perhaps less of a legal perspective, because we all know that the process of restoring rule of law is very complex, and the legal dimension, although it is complex, is merely one of the dimensions. The social aspect, the psychological aspect, the political aspect, the communicative aspects are also equally important, and they make the process complex. And all these dimensions, all these aspects can pose risks to the process. I want to share a thought from last week. Last week I was in Strasbourg attending meetings organized by NGOs, meetings of NGOs from all Council of Europe member states with the Human Rights Commissioner. And that made me realize how dramatic the situation of democracy, rule of law, and human rights in Council of Europe member states is. I am not one for lofty speeches, but there I was the only person who had something positive to say. And that's when I understood it very clearly what an extraordinary chance we still have. A chance to rebuild, to restore, reconstruct rule of law, and to seriously treat the values that I believe many of us adhere to, that not only doing lip service to them, but also having them in our hearts. I think I can say this, although this might sound a little, again, lofty, that we do have a moral responsibility for this process to succeed, no matter how complex it is and how vulnerable to various dangers. I hope this conference will help us think about how to achieve this. Thanks again to all our partners from Poland and abroad, including the Embassy of the Federal Republic of Germany for their support and for helping us organize this important event. And I know thanks are also due to those who have organized. Normally, thanks to the organizers are made at the end, and at the end we have fewer participants. I hope that this time we will all be together at the end of the conference. However, I do want to thank everybody who worked on organizing this conference and who will continue to be working on it, especially two people without whom this conference would not have been possible: Krzysztof Izdebski from the Stefan Batory Foundation and Małgorzata Szuleka from the Helsinki Foundation for Human Rights. Thank you very much. And I want to welcome Minister Adam Bodnar. Thank you for sharing your thoughts with us. So welcome one, welcome all, and have a great conference. Thank you very much. And after these words of introduction, we can proceed to our agenda. I want to ask Dr. Anna Materska-Sosnowska, a member of the board of the Stefan Batory Foundation, to take the microphone and to introduce the first item on our agenda. Thank you very much. Thank you very much, gentlemen, ladies and gentlemen, Minister. And now it's my pleasure to invite our first panelist, Professor Adam Bodnar, who is the Minister of Justice of the Republic of Poland. And when we talk about a candidate, a civic candidate, this was our civic candidate for the Ombudsman, and which also explains the hopes we've pinned upon his becoming minister. So, Minister, first it'll be pleasant. First, we'll hand it over to you, and please feel free to say whatever you choose. Ladies and gentlemen, eminent distinguished guests, thank you very much for having me at this conference. I'm a little worried about the unpleasant part that's been announced just now. Frankly, I don't know whether the first part will be all that pleasant, but we'll see. And now I think, ladies and gentlemen, that if we were to look back to over the last year of restoring, reconstructing, rebuilding rule of law, we would need to recall two dates: the date of the elections and December 13th, 2023. For me, it's been a year, but for me, there's still 2 more weeks, 2 weeks of work during which a lot can happen. A lot can happen that can impact our overview of the last year. So the year is not over yet, and there might be important events that could impact the way we see this last year. If we look back, however, we would need to consider the state of the country on December 13th, 2023. That's when the two-week government ended its term of office. During its 2 weeks in office, it did, for instance, support, it backed, I'm speaking of the Ministry of Justice, which decided to back the pardon of Robert Bąkiewicz, a Polish nationalist. That was one of the decisions made by the Ministry of Justice, and as well as decisions regarding the operations of various other ministries. And after the 2-week term of office of that government, many people felt that the new government elected on October 15th would not be able to take office smoothly. But I think that in terms of the rule of law, the condition on December 13th, there was a minefield of various institutions and personnel, and so it wasn't clear, it wasn't self-evident how the changes would occur. I'm thinking of the prosecutor's office, the National Council of the Judiciary, as well as the Constitutional Court. In many institutions, there are judges adjudicating who have been appointed by the National Council of the Judiciary, and they also impact. I'm not speaking of the Electoral Commission or the National Broadcasting Council. We have inherited a sense of impunity, the sense that over so many years, no mechanisms of accountability for abuse of power have existed, so this will continue to be the case. And there's also very weakened international relations, loss of trust in state institutions, and which was a priority in the first weeks and months. There was the National Resilience Reinsertion and Resilience Facility, which the funds were blocked. So what happened on December 13th, 2023, when the new government took office, they had to deal with obstacles, and this is an ongoing process. So when we consider the prime objectives of restoring rule of law over the last year, there was institutional reconstruction to the effect that to the extent that is possible in terms of international relations, and also regaining the trust of the European Union and other international organizations, also in bilateral terms, accountability for abuse. And one thing we lose sight of, and which is also important because it's increasingly becoming part of our everyday reality, there's an integrity and a transparency in the bodies of the state, in state institutions. So as for institutional changes, as I said at the beginning, they're at the ministry, with the support of my wonderful team and my deputy ministers, directors, some of whom are present here today. We're doing everything we can within the limits of the law to accomplish real change. I think a good example is changing the presidents of courts in over 120 courts. This was done in keeping with the law, with the consent of the collegiate bodies of the courts, as well as giving the judges the possibility to select candidates for presidents, appointing ad hoc disciplinary advocates to cut short the shameful disciplinary proceedings, changes in institutions like the National School of the Judiciary and the Prosecutor's Office. We have competitions to staff new institutions, which are also changes in the prison service, which is the responsibility of Minister Maria Eichhardt, and also changes on seconding judges and prosecutors to the Ministry of Justice, curtailing that procedure to the extent possible, without, of course, impacting the operations of the ministry, because if we have, for instance, professionals on extradition who have been working in the ministry, it's difficult to find similarly qualified experts who would want to come and work at the Ministry of Justice. And finally, the legislative process for codification commissions, as well as an expert team on European Union law, which team is advising us on drafting in the days preceding the Polish presidency, as well as a task force, a team which investigates difficult cases, a team on the Kamilek Act, which is about child abuse. And then there is also important work to be done with the National Council of the Judiciary. On December 20th, the Parliament adopted a resolution on the NCJ. It froze new, but I regret that the Supreme Administrative Court did not follow suit. Then there was another piece of legislation which also had problems owing to the opinions of the Venice Commission and the amendment by the Senate, but there's the future of the National Council of the Judiciary remains open, remains to be determined. I'm also thinking of matters having to do with the budget for next year and the working of the National Council of the Judiciary. We need to go back to one of the main obstacles, the main problems we have with the reform process, namely difficulties in finalizing the legislative process, given the possibility of a presidential veto or referring a preemptive referral of these draft legislation to the Constitutional Court. Over the last years, we had also a very divisive in the legal community debate on what to deal on how to do with the status of judges. We have Małgorzata Szuleka and Krystian Markiewicz sitting next to me, but in public debate they're not that close, let me say, metaphorically. So we have the opinion of the Venice Commission. There's also a draft piece of legislation being drafted by the Codification Committee, and the so I think this will be a signpost. This will give us some idea of the solutions we need to adopt. But I'm also seeing that as regards the status of judges, what's also important is the approach to judges who adjudicate, judges who were appointed following 2018. For me, an important document was the guidelines of the Prosecutor General on the status of neo-judges who adjudicate in the Supreme Court. I think this is a clear message sent by the Prosecutor's Office. As regards the prosecution service, although there's a lot being done. One of the first decisions of the government of joining the European Prosecution Service, yesterday I sent a list of prosecutors to Laura Kövesi, a list of prosecutors who were seconded, who will be in the European Prosecution Service. We're also completing work on an act that will regulate this, also issues on the Code of Criminal Procedure. And the Polish European prosecutor will, I think in December, their name will be announced. There is also an important debate regarding changes in the National Prosecutor's Office, National Prosecutor. But I want to point out how this National Prosecutor was elected. This was selected. This was done by way of a competition. This was done, and this needs to be done. There's also a public hearing of candidates for a national prosecutor. For me, what's also important is the National Council of Prosecutors is gaining in importance. This is a body that was insignificant, and now it's becoming a relevant actor in discussions on the future of the prosecutor's office. Its debates are being transmitted. There's also a lot being done in the prosecutor's office to improve the communication possibilities, as well as the reform which is gradually being carried out on the disciplinary courts for prosecutors. In December, there will be an event at which we will nominate 88 new disciplinary judges to the disciplinary court, which answers to the Prosecutor General. It was the Assembly of Prosecutors that elected these judges, mind you, and also the process of splitting the Ministry of Justice from the Prosecutor General, the Venice Commission. There was an opinion, and following that opinion, we improved the initial draft, and now it's being heard in the Council of Ministers. I hope the Council of Ministers will adopt it. And this opinion of the Venice Commission has proven very helpful when it comes to restricting the influence of politicians over the selection of the Prosecutor General. And finally, the Constitutional Court. I'm very grateful for what the president of the Helsinki Foundation said, that the cooperation with NGOs and these two drafts had the support not just of the ruling coalition, but also of various experts and authorities. I remember a news conference organized together with retired Constitutional Court justices, at which we presented a packet of changes. There was a resolution of March 6, 2024, a resolution and also drafts, as well as a proposal to change the constitution, and the public debate that is taking place. It's very difficult. The situation is difficult, and the relations regarding those interested in restoring rule of law and the body which calls itself the Constitutional Court. Proof of these difficulties is in that the ruling coalition did not nominate new candidates to the Constitutional Court, and the budgetary debate will be about the budget of the Constitutional Court for next year. And I think at one point, sooner or later, we will all understand that we will need to rebuild an independent Constitutional Court. Ladies and gentlemen, the process of restoring rule of law is not just changes in the political system and institutions. It's not just changes on the role and position of various individuals in the judiciary, but it's also a process of accountability. These are closely related, as I see it, not only because of ongoing politics, but also due to the fact that these are connected vessels, because many of these individuals were involved in the process of creating these structures of government. As regards accountability, I want to identify 4 areas as I see them, 4 areas that I'm trying to follow First, judges and prosecutors as victims of the changes. So all those who, over the previous years, were thus harassed and made the subject a target of disciplinary proceedings. These ad hoc advocates are gradually remedying this, and some newly appointed ad hoc advocates are also being involved in this process. Then there's the hater gate. This was accelerated, it sped up ever since. So there is the so-called hater gate, and work on this speeded up ever since the district prosecution service in Wrocław waiving immunity and also lifting immunity, as well as information about this proceeding has become the subject of public debate. And I think this sword of Damocles is increasingly not so much hanging, but I would rather say that the mills of justice grind slowly, to translate a Polish proverb literally, as regards this hatergate. So I also think that we sometimes forget that the victim, that prosecutors and judges who were victims of abuse of power were those who were also surveilled by using Pegasus software. Recently, there was a special committee, Judge Beata Morawiec and Ewa Wrzosek also. These were judges, advocates, and prosecutors against who were the target of surveillance using this technology. And so on the one hand, there have been notifications by people who were affected by various abuse by the government. We have, from judges and prosecutors, we've had about 15 complaints. Maybe we haven't counted all of them, and I'm trying to make sure the prosecution looks into all these cases. There's also civilian suits by victims, for instance, Krzysztof Parchimowicz or Christian Markiewicz, as well as other judges or prosecutors who were in one way or another affected by this harassment. And for me, this is also a question of accountability, but also apologies. There was a time when I apologized for the words spoken by my predecessor, Mr. Ziobro, towards Judge Justyna Kossak. And these are things that are relevant, and this also related to what we're working to what Dominika Ziętara is working on at the ministry, SLAP suits. So all the various slaps by the ministry against other individuals. There's also the question of accountability of NGOs and citizens who were in one way or another repressed or persecuted. Some work has been done. The prosecutor's office has conducted a review of cases that were quashed in the recent years. Some were reopened, but we need to re-examine this thoroughly together with the Ministry of Internal Affairs and Administration, because if some cases, especially those during the pandemic, were at the interface of the police and the court, the prosecutor's office might not have full information, but I do assure you that I am in talks with Minister Siemoniak of the Ministry of Internal Affairs. We're trying to find a solution, the best approach. And finally, as regards the process of accountability, there's a number of issues from the past where there have been accusations that these were motivated politically. And it's easy to say, but it's not that easy to prove, to actually decide what is to be done, because this can be at various stages. There are cases which are being examined in the prosecutor's office and processed into the prosecutor's office, and others are in court. And in court, it's much more complicated. So this is also one of the things that I'm thinking about, that I'm examining. And it's especially in the prosecutor's office, we're trying to respond to the notifications, to the complaints filed by NGOs. There was a letter signed by Lech Wałęsa, so this was, and the prosecutor's office assures that by the end of December it will provide a comprehensive response. As regards, finally, accountability, there's also accountability for all abuses of power, and three scandals, three committees, Pegasus, the visas, and the so-called envelope elections. All of these requires a special committee, and the prosecutor's office needs to be involved. Finally, the Smolensk Disasters Subcommittee, which was headed by Antoni Macierewicz, the Justice Fund. This is an extensive subject topic in itself. And I think that what we've done, what the prosecutor's office has managed to disclose, is merely a third of the issues, of the relevant issues. There have been complaints by state forests and regards state treasury companies, earmarked funds, and so on. All these matters require a thorough investigation. And furthermore, these are abuses, which are sometimes merely abuse of executive power, and sometimes they are cases of fraud and financial fraud. So I think this is a process of restoring various specific standards. And in closing, I don't see this process of accountability as one symbolic, one token case that we will, and everything will be okay once we've sorted that out. No, we need to look back to the past. We need to consider those cases which haven't been addressed properly, and also look at all the abuses over the last few years. And I want to emphasize that this needs to be done properly and legally and in keeping with procedures. Let me once again say that this tone, that the debate, that also among NGOs, civil society, as well as various influential individuals who want to speed up the process. This is not helpful, and what specifically concerns me is when people who for 8 years sought to uphold rule of law, but informally, they believe that, and they say that in this case, the process of accountability, there should be a sheriff who steps in and cleans up. No. Society, civil society, and public figures, individuals should trust the prosecutor's office to do everything in its power to ensure accountability step by step. Now, ladies and gentlemen, in summary, as you can see, the process of restoring rule of law over the last year, as the last year has shown, is a very comprehensive, very complex process at various levels, legally and also in terms of emotion, social, public emotions, and also when it comes to communication. So I think that what we still fail to appreciate is that 8 years of consistent undermining of institutions is a large gap or rift in our country, and it's difficult to restore, to remedy the what happened over the last 8 years within 1 year. So I've always been calling for patience, and what's also important is the support of European institutions. There is a benchmark. There is the case law, the jurisprudence of the court in Strasbourg and Luxembourg, that this provides us with a benchmark, some sort of to define the standards that we want to put into practice. And the thing that I feel we fail to appreciate sufficiently, or we tend to take for granted, is that over the last year we managed to introduce practices in public life that have become a standard, especially as regards rule of law, respect of rule of law, and these have become a standard so much so that they haven't been noticed by the media. There's a competition for we have for justice of the European Court of Human Rights. So we had over several dozen candidates. It was a transparent process, and the Council of Europe has considered it an exemplary process for other Council of Europe member states. It was a competition that we organized, and we simply took it. We simply believe that this is the way to go. That's how it should have been done. Also, issues regarding competitions to fill various positions, public information, dialogue, freedom of information, dialogue with and civil society. This is something we ought to pay attention to, because on the part of the administration, this does require time and effort. And I feel, ladies and gentlemen, that now a year in, we're still heading in the same direction, although the flow, the current of the river tends to meander sometimes, and it isn't always entirely straightforward, but we can't lose our resolve. We can't lose our belief that what we're seeking to do is to create a stable democratic state, a state that, as President Novitsky said, a state that will also be able to set the tone for the European Union and the Council of Europe. I think we bear responsibility. It's our responsibility not just to improve the situation here in this country, but also to provide support to countries that might be in crisis. Ladies and gentlemen, thank you very much for your attention.
Thank you very much, Minister. Of course, when we look at the system, I fully agree with what you said. However, I would like to ask a question, because it's not a coincidence that I started by saying that you were the ombudsman, because we pinned great hopes on you, not just as a politician, but also as a professor, an ombudsman, a person who seeks compromise and peace rather than pursues a single political option. What didn't work out, actually? Maybe you could tell us that. We know what the conditions are. We know that there is a very fine, thin line between rule of law and using rule of law that was dismantled in that respect previously. what could have been done better or what hasn't quite worked out. So, ladies and gents, I am in a political role, and I think that everything that I have done over the past year was significant in terms of rebuilding rule of law. I'm proud of the work we've done, myself and my colleagues, and I don't really see myself as somebody who would explain now what didn't work out. Okay, so we have some processes that are planned for 4 years rather than just a year, but I would like you to provide a sort of an overview now from a professor's vantage point, not just a political one. What are the changes that citizens can actually experience? What do I mean? You also used the expression that the sense of impunity has declined, and that is something positive. We want that. However, if we look at different pieces of research, there's no sense that this has happened. So what has actually, we know what happened systemically, we know what happened on the political stage, but what has actually changed for the citizen? Because in order to introduce reforms, we need civil support behind us. We need people to have faith in us. I don't know what research you're citing. I've seen one study. So people were asked, how do you view the activities of the Ministry of Justice, or how do you assess the process of restoring rule of law? I think 37 or 38% would say things are okay, relatively good, and 35 would say things are terrible. It's a catastrophe, it's a disaster, including various invectives to targeting myself. So we need to keep in mind that this undermining of various institutions is also the result of deep political polarization. If the process of restoring rule of law means challenging the reforms or the legacy of reforms that were introduced in Poland over many years, then perforce those citizens who see the past 8 years, the previous government in good terms, they will be questioning the current process. So I'm trying not to see that something didn't work out. I realize that there are difficulties, and I'm using all the tools at my disposal in order not to desist, in order to counter these difficulties and to do whatever is possible and to introduce lasting change. So not just, quick fireworks regarding this or that institution, but introducing changes that are lasting and enduring. So for example, if we were to look at the prosecution service, I don't know how the citizens see this. We haven't done such studies. In fact, we are very cautious when it comes to spending public funds on research, studies, etc., because it always makes people ask, why are you doing this research, or is this money being well spent? However, I believe that it's important to the citizen that this process of accountability is continuing, is ongoing, and that those who could be deemed responsible for various financial crimes or abuses of power, they can't sleep soundly. They will be called to account before prosecutors. In fact, indictments have been formulated against some of these individuals. So now to return to the so-called ordinary citizen. One important event for me, I didn't mention it because it's sort of on the sidelines of the main subject, the issue of improving the effectiveness of courts. So I'm very proud of my plenipotentiary for consumer rights, Aneta Biurowska, because she spent the whole year in building communication and persuading people to ensure that we have as few difficulties as possible with loans taken out in francs to increase the number of settlements, and this number has increased tremendously. So that is something that truly affects the ordinary citizen. And now that people have settlement on these loans, they're able to return to talking to banks, getting other loans. As for the budget, we were able to guarantee, put in over 1,000 jobs as assistants, court assistants. That is going to translate into more effective courts, and citizens will doubtless feel that it improves their quality of life. But there are two levels. One is institutional reform, repair of the judiciary, and here we have a work cut out for the long term, and then improving the effectiveness of court proceedings, and that has worked out quite well so far. We are talking to judges associations and NGOs. So since you've called me up in my professor's hat, maybe it helped that we selected those codification commissions which are working very well and preparing large-scale packages of change. And I think there's a level of trust in members of those commissions as professionals that led to accepting the nomination from the Prime Minister. Well, doubtless, it's probably one of the most open ministries and diverse, but also attuned to what people are saying. So speaking of political roles, it's the only ministry that has been called to account and has actually presented progress in terms of restoring rule of law. But what about the neo-judges? Hundreds of thousands of decisions issued by them. Almost a third of the judges in Poland have been through the neo NCJ. How do we stop this process without creating chaos and delays in courts? That is why we have the opinion of the Venice Commission, which says that generally, even if we reassess judges, we need to make sure that on the legislative level we need to define the status of their decisions, of their rulings. As for what the law says about what to do with those adjudications, there might be some leeway to question those proceedings. At the same time, those decisions will remain in force, have been enforced. The prosecution codification commission has issued some guidelines. We're working on it. I don't think there's any disagreement as to what to do here. We have an interesting systemic experience, political experience. I think it's been of great use to us that we've had a whole variety of political experiences over the first 20 years of the political transition. And I'm looking to Eva Łętowska, who wrote the justification to the court decision on court assessors. So those decisions can remain in circulation because it would create more harm for the legal system if they were to be challenged. So for the stability of legal circulation, they are kept in place. As for neo-judges, we are currently looking at the opinion of the Venice Commission. We're preparing a draft law. And first of all, we need to recognize that, yes, this evaluation should proceed. It is admissible and advisable. Secondly, it needs to be done quick after the laws are coming to place. Thirdly, it should be a method that allows us to group these judges into different categories or cohorts. This has to be accomplished by a court status agency, and there should be some way of appealing individual assessments. However, it shouldn't lead to suspension. So this is a difficult equation, and we're trying to propose a solution that is coherent, that aligns with our constitutional system and international standards, but also feasible, implementable, so that we're not in a situation where we will get mired in the evaluation process for many years, and this chaos will persist and will be visible for citizens and won't will put courts into disarray. However, we needed those months of debates, accusations, and sometimes bad feelings, bad blood, in order to attain a stage when we're able to talk and look for the optimum solution. That's what democracy is about. We look for solutions, and first we might start out by disagreeing. Since my time is almost running up and I have to give some time to the floor, to the audience, what is the most important plan that you will be implementing in the near future? What are the main things that you want to focus on in the short term rather than in the long term? So in the short term, we have another 6 months until the presidential elections. We need to use this period for legislative work and to prepare laws that will meet all the criteria we have been discussing. It is our hope that perhaps the outcome of the presidentials will give us a chance to finish up the process of repairing rule of law. So again, it's not a period, it's not a time for waiting. We've solved a lot of mathematical equations. Things are easier now than they were at the beginning, and that's the first thing. And secondly, I would focus on the prosecution service. Please note that all those investigative teams, I'm not saying they're gaining momentum, but they are maturing in the work that they're doing. That might be misunderstood by public opinion. Public opinion often thinks that if there's an article in the press saying some journalist, thanks to his or her informers, found some secret documents, the journalist makes accusations and says, okay, look at what's happening, doomsday's coming. No, the prosecution service has to do its work. They have to collect evidence. They have to follow all the procedural guarantees. We have some of the country's best lawyers on the other side who have taken these cases. So the prosecution has to be very careful, avoid any mistakes, do their job well, because we need to keep the results in place in terms of the indictments, the charges, etc. It has to hold up. It has to hold water in court. And all of it takes time. The individual prosecutors need to familiarize themselves with each case. It often takes courage. It also requires an understanding of the various layers to each case. And also it requires consequence, consistency, resolve. So public opinion that keeps saying faster, faster, it's not helpful, because legal work is characterized, as you well know. You can't write a monographic volume in 1 year, but if you want to write a good book, it takes 4 to 5 years. And the same thing for an organized criminal group. You can't do it in 3 weeks. You need 6 months, a year, maybe even 2 years, in order to unravel all of the issues, and then to press charges. So it's important that we think of this process of accountability in that way, as a long-term process. Another thing I've alluded to, in December, I will be trying to work together with the Ministry of Interior, all those civic groups that had been protesting for many years. We focused on those big cases. However, there are many smaller stories sort of involving police, people who were protesting, who were harassed, who were charged. A few days ago, I talked to Paweł Kasprzak. I'm in touch with Marta Lempart. So this is something that I'm going to try to fix in December. Thank you very much, because that also is very close to the citizen. The world can live without a book from me, but not without a well-working prosecution service. We have 15 minutes left, so if you could ask your questions in a concise way, because our guest has to leave. So, I apologize for sitting, but please be concise. So I'm rushing to take the floor because my name is Małgorzata Fyrfet, former Solidarity. And I have been through 8 years of protesting in the street. So my question is as follows. I wouldn't want to be in your shoes today. However, for me, you're still the ombudsman, and that won't change in my mind. Plus, now on top of that, Minister of Justice. And that is precisely why, at the very end, you touched on matters close to the citizen. I'm surprised you did so at the very end. So I want to make sure, will the police be called to account? Will the police be held responsible for hitting us, keeping us out in the cold, spraying us with tear gas, breaking our arms, holding us in remand prisons, etc.? I know it's not the fault of individual officers, the officers who say broke somebody's arm. There were decision makers on site who gave them orders. So I would like all of these people to be called to account for their actions, because the way they handled us, they treated us was lawless, was outside the law. And to conclude, I want to say, you don't need to explain yourself. You shouldn't have to explain yourself. You should say, this is how we're going about it, because that's the law, that's how courts work, that's how the prosecution service works, and I trust you. Thank you. Maybe we could collect a couple of questions and maybe reduce the light, turn down the lights. Hubert Dudkiewicz, XIP Votum Association of Legal Professionals. Nobody doubts that you have good intentions when it comes to fixing the rule of law, to make that a rule of law process in itself, in line with the recommendations of the Venice Commission. And I agree with what you've said about the verification of judges appointed after 2017. However, we have some doubts as to whether all decision makers, all the members of the Codification Commission understand the recommendations of the Venice Commission in the same way. You, as somebody who will be overseeing this process, do you already have a draft law that you will send for opinion to the Venice Commission to eliminate any doubts at that stage? My second question concerns the whole process of restoring rule of law. You're mostly drafting laws in view of the presidential elections next year. What if the presidentials don't go according to your desires? Is there a plan B so that those 2 years of work don't go to waste? Thank you. Thank you. Monika Haczkowska, a constitutional lawyer, but here wearing a different hat as an advocate, mediator, Legal Chamber, Wrocław. So, alluding to what Dr. Materska-Sosnowska said, how could we, in order to help citizens at this difficult time, because we know there's a problem with neo-judges and lengthy court proceedings, how can we help the judiciary? Because we mediators are ready on the sidelines, but we're getting blocked. There's a blockade between judges and mediators. How could that be overcome? How can we, what sort of support could we get from the Ministry of Justice in order to clear those channels of communication? We can still take 2 more questions. Marek Dąbrowski, I'm an economist, but I would like to ask about the announcement. It wasn't you who announced it, but a temporary suspension of the right to asylum. Marcin Mucielski, Open Dialogue Foundation. 2 short questions. First of all, a prosecutor is nominated, delegated by Minister Ziobro when he was in office. Once they leave their jobs, when will they leave their jobs? Why are they still? Why are they auditing their own cases or cases that they oversaw, like Prosecutor Lerman? And Professor, three questions regarding precisions, mediations. Will judges be assessed and promoted in terms? Inaudible question. Okay. So, can we hope that promotions will happen? Cooperation between the Ministry of Justice and other ministries. Of course, nobody is suspending the right to asylum, but will there be audits by the Ministry of Justice at the Polish-Belarusian border? Thirdly, cooperation between the Ministry of Justice and the Ministry of Health in order to put an end to violations of the law in facilities that implement preventive measures.
Okay, ladies and gentlemen, thank you very much for your questions and your comments. The first thing, as regards excuses or explaining myself, I'm not explaining myself. I'm trying to present all these circumstances, and thank you very much for your continued trust. But it's not the case that civil society or the public opinion always understands processes and the actions, what's being done. Sometimes it's worth explaining how the prosecutor's service works. And as for civic matters related to individuals, one of the things I requested, I instructed my people to do was to review all prosecutors' cases regarding taking part in demonstrations. 2 cases were reopened. This is the case of the young woman whose arm was broken during a demonstration, and also an internal security agency car driving into a crowd of demonstrators. As for beating, I think the matter is still being analyzed. So that's one thing. There's the police, and there's also the accountability of individual officers for abuse, disciplinary mechanisms, disciplinary procedures, whether they were in place. And there are cases which led to fines being levied for taking part in demonstrations during the pandemic. These cases were brought to court immediately. They also need to be reviewed. Not in all cases was a ruling handed down, and even if it was, perhaps it might be revisited. And the reason I'm answering this, there's a question for accountability, and this does require my cooperation with the Ministry of Internal Affairs and Administration. Now, as for the question of the KSIP Alumni Association, I'm glad that every day we are reforming the institution. The professor, together with Judge Waldemar Żurek, who is currently the deputy director of that institution, are doing their utmost, to make KSIP great again, the National School of the Judiciary and the Prosecution. It is a matter of time. The school is getting funds, and we're also thinking of how to support candidates As regards the work of the Codification Committee for the organization of the Judiciary and the Prosecution Service, the committee is working. The chair is present at this conference, or will take part in this conference. We're working with the committee, although we want to ensure its continued autonomy. But at the end, it is I who take political responsibility for the changes, and I have to explain the changes for the benefit of the ruling coalition. I'm trying to work in such a way to reconcile our positions, because we do not differ in this respect, and I think the longer, the more we talk, the more we can reconcile or harmonize our positions. And at the second stage, I assume that when the next draft of the law is, or the first draft following the opinion of the Venice Commission, we will subsend it to the Venice Commission. This, I think, is self-evident. Since we've asked the Venice Commission to come on board, we will continue talking to them. On mediation, there's a whole range of changes on mediation drafted by Minister Rudzińska-Bluszcz, the purpose of which is to ensure greater professionalism of mediation and to encourage judges, courts to call in mediators more often, and also to provide higher compensation for mediators. And as for bridging the gap, I'm glad to be working with Jarosław Gwizdak, who's a former judge and now a lawyer. He's the minister's plenipotentiary on the judiciary, and he's looking for ways of strengthening lay judges, the position of civilian lay judges in the system. There's a lot that remains to be done. And as for the border and suspending the right to apply for asylum, during this session I wouldn't want to repeat the findings of a public hearing held several days ago with the participation of Minister Dorowska and Deputy Minister Duszczyk, but as regards the suspension of the right to asylum, I believe my role was, during a session of the Council of Ministers, I successfully adopted a amendment that the rules, that the acts of law should provide parliamentary oversight, protection of vulnerable groups, as well as other states, namely Finland. And I think, and look at the influence of other countries. So that's how I see my role in the government, to have a say, have an influence on these actions. And as regards the cooperation with Minister Siemoniak, this is an intense, everyday cooperation. It's not. I think I want to mention two other things that are also relevant for me personally, which also have to do with my previous capacity. Last week, we had a very good meeting with NGOs on enforcement, execution of the Strasbourg ruling on surveillance, and we will continue to cooperate with the Ministry of of Internal Affairs and the security agencies to have proposed revisions on surveillance, or limiting surveillance, or reforming the system of surveillance. Then fighting trafficking, combating human trafficking. There is a task force, there's a working group that will be working on a draft piece of legislation. I'm convincing the minister to be involved in ratifying pending international agreements. I don't know if the government has already, or if it hasn't, it will soon. We intend to ratify Protocol 3 to the Convention on the Rights of the Child. As for cooperation on the center in Gostynin, the cooperation for unreformable convicts, there is work with the Health Ministry. Minister Erhardt and Minister Konieczny are working to improve conditions in that facility, in the facility for in Gostynin. And on the question regarding prosecutors, Three prosecutors have been suspended so far for specific things. Prosecutor Romelczyk Ziarkiewicz, the prosecutor from Lublin, notorious, and prosecutor Tryfon Wilkoszewska. But in all individual action with regard to the prosecutors need to be consistent with the Act on the Prosecution Service, and this needs disciplinary proceedings and a decision by supervisors, including myself. For Madam Tryfon Wilkoszewska, there was a decision made by Prosecutor Wilkmaitis, and second, there are also matters of the disciplinary courts at the prosecutor's offices. As for audits, I can assure you that I'm doing everything in my power for the audits to ensure that the audits are carried out by individuals who are fully independent and who can responsibly and consider all the facts, all the relevant facts. Thank you. Minister, how many prosecutors are there in this country? 5,800, nearly 6,000 prosecutors. And let me just say, just to give you an idea of the challenges we face, take a look at one datum. When we have judges, we have 9,500 judges, and of whom 3,500 belong to the Polish Judges Association. There's another association with over 200 judges. With prosecutors, we have 5,800. Lex Super Omnia, at its height, at its peak, had about 240 members, including many retired prosecutors, which shows the challenges we face without looking into the positions. But my job as a prosecutor general is to encourage each of these 5,800 prosecutors to respect rule of law and their mission to prosecute crime. And I think that every day I'm succeeding. And that's what. Let's skip our summary and let's have a coffee break. Do rejoin us at 11:30 for our first panel with Professor Ewa Łętowska, Minister Bodnar. Thank you very much, and so keep it up. Perseverance.
said, I think that we will comment on it in a moment in choice company. We will also say how complicated the process is. Of course, it's easy to ruin the hard things in politics, in the state, and in life, especially as it's very hard to rebuild. Moreover, I think the notion of rule of law is very broad, and we will be talking about this as well over the next hour and a half. We have planned half an hour for a discussion with the audience, for a Q&A. Quite a few of you in the room. If anyone is looking for a place to sit, there are places at the front. My name is Krzysztof Izdebski. I am a member of the board of the Stefan Batory Foundation, and it is my pleasure to moderate a panel which doesn't really need moderation when you look at who is in it. I will simply assign topics maybe and look after the time, for which I apologize in advance. It's a thankless duty, but at least it's something I'm qualified to do. So we have with us Professor Ewa Łętowska, who needs no introduction, I suppose. In fact, she was already mentioned before. Professor Aleksandra Kustra-Rogatka from the Nicholas Copernicus University in Toruń. Professor Judge President Krystian Markiewicz, Chairman of the Association of Polish Judges Justitia, and at the head of the commission, and Maciej Nowicki, who was here on the stage before but now wearing a different hat. He now appears as chairman of the Helsinki Foundation for Human Rights. So I will face our panelists now, and you in profile. Maybe the first question about your impressions and what the minister said, and also what the minister did not say. That should also be touched upon. So let me start with in the order that we're sitting in. So I will be talking, I will reflect on method, the method of evaluating anything, because as we're sitting here, each of us is wearing one hat or several hats. I am the hat of a legal scholar, a professor, but I am also a retired judge. Mr. Nowicki wears an NGO hat. Professor Kustra-Rogatka has one hat, two hats, one hat as a professor. However, Mr. Markiewicz has three hats: an NGO hat at the head of the Codification Commission, that is an official function, an official role, and he is also a professor. So after one of the questions addressed to Professor and Minister Bodnar was that he used to be ombudsman, now he is minister, but however, he should still be ombudsman. However, with the full power of my experience behind me, I would like to firmly state that one needs to decide what one is. Because every hat, and according to Pierre Bourdieu, all the habits, or each habitus that we are in, imposes certain limitations and obligations on each of us. So, of course, many of us have several different roles. However, it is often difficult. Those roles are in collision with each other, and sometimes we need to impose limits on ourselves, and that is why I oppose what one of the discussants said about Mr. Bodnar wearing two hats simultaneously. That is impossible, not feasible. He is currently minister, and one should only address ministerial expectations to him. To be clear, I fully understand that there are expectations, and I understand the problems inherent in the existence of every hat, including my own. For example, I am very critical with regard to the academic community in Poland when it comes to converting to matters related to conversion to rule of law. But I'll leave that for the end. However, you in the room, the auditorium, is not homogeneous, although most of you represent NGOs. And I apologize for this arbitrary or arbiter's tone, but that is due to my age. You must be aware of your own conditioning. It is both an advantage and your baggage. Because you are, and I apologize in the most noble sense of the term, you are lobbyists for the causes that your NGOs fight for. So that is my first remark, because the discussion that was unleashed after the first speech, what I found missing in it was self-reflection. And that is not a drawback, but it's something that we have to keep in mind. And moreover, NGOs are part of the pressure. However, they cannot require somebody who is in a different role to renounce that role, even for righteous purposes. So I have a whole list of points I'd like to make. There's another problem, and you started with this rule of law. The program is so designed that the keynote was delivered by Minister Bodnar, but he's not the only one who should be sitting here, who should be up here reporting. We should have the Minister of Health because of Gostynin. We should have Mr. Siemoniak. I don't remember what he's for, Internal Affairs, because it is the shameful issue of the Polish-Belarusian border. I won't delve into this. You all know where the problems are. It's a disgrace. Why is it a disgrace? However, is it the law that's bad? We have a certain lack, drawbacks due to our formation, our education. We often think that if we write a law, that's great and that's it. We are now in a situation in which the legislative track that is closest to us, whether we like it or not, whether it's good or bad, it has been excluded, ruled out. So where do we have reserves? Well, the reserves are in perfecting our practices. Our presence both in the Council of Europe and within the European Union presupposes that the law, so what lawyers believe in, is not just made up of provisions but also standards. And I keep repeating this like a mantra. Currently, we are called to account for adjective law, abstract, potential, concrete, and situational provisions. Situational, that being standards. If you're asking about whether people will be called to account, police will be called to account for their disgraceful behavior, you're asking about the two adjectives that were missing at the right moment. If you're asking about provisions that regulate using force, that's just part of the issue. So we need to look at rule of law under all these aspects. We currently have no recourse to perfecting practice. Of course, NGOs are very good at this. They've been victimized not just by provisions, legal provisions, but by the application of law. However, it's also a problem that academics on the Codification Commission who are creating laws, who are evaluating laws, like myself, they, for the most part, are not aware of this four-adjective structure, this need for a four-adjective structure evaluation rather than a two-adjective evaluation. So we have too few codifiers. We have we're formulating our questions wrongly, and we're formulating our expectations imperfectly. Of course, as Minister Bodnar noticed, a glass can be half empty or half full. If we start from a full glass, we'll boast of our achievements. Bodnar did a bit of that. However, if we are talking about expectations, we're looking at the glass that's half empty or mostly empty. Whatever the case. What am I driving at? Rule of law is a whole set, a whole battery of vessels, of glasses, of that are half full, half empty, and have different levels of liquid. So in order to assess whether we've done all in our power or perhaps we've failed to do something that was doable, we have to talk not top down, starting with rule of law. We need to speak bottom up. We need to talk about specifics. I'm sorry for making a mess. Another issue. We need to reflect. If we want to call people to account, we need to ask precise questions. Another issue I'd like to highlight, restoring rule of law. Here we're starting from a start line that was described by Bodnar. We know what it looks like. There's a constitution, whether it's broken, violated, skirted, manipulated, misinterpreted, etc. However, it's not from start to finish. It's a race. It's a run. It's like sailing. It's like tacking and sailing. You cannot go directly to your destination. The government needs to deal with coalitions, and you have pressure, lobbying, pressure from NGOs, for instance. Then there's a fifth column. We need to face it, both within the prosecutor's service and in the courts. It's not made up of open opponents of restoring rule of law. It consists of the cautious types who want to lie in wait, who want to wait and see what happens without taking risks. Just note, we mentioned a statistic regarding the participants of Lex Super Omnia, or the active members of Justitia. It's not the whole, it doesn't represent the whole population. So in that case, if we're setting out to evaluate, let's be precise. And it's not an accusation I'm making with regard to your questions. It's an accusation against the orators who are defending some precise position. If Mr. Bodnar was here, I would respond to him. Furthermore, so tacking rather than taking the most, taking a direct route. When will tacking get us to the finish line, or you to the finish line? God only knows. There is no finish line, in fact, even in the most judicious countries, the most lawful ones, the ones we take as our models. I apologize. Things happen. There are stupid judges, judges who sell themselves, opportunists, unwise, corrupt people. So we need to follow the rabbit, but we don't know if we'll catch it. So if I was to assess what is happening here in Poland, I would say, and I repeat this, I am a cautious optimist, in the sense that what they declared in the parliamentary resolutions, the need to enforce European Court of Human Rights and European Court of Justice rulings. There's a path that's been laid out, and we need to start there. Consultations with the Venice Commission, yes, of course. Because, however, if we agree on something and it loses in the international courts, then our tacking has been unsuccessful. Why? People ask, why doesn't the Venice Commission tell us exactly what to do? Well, that is its nature. It's not allowed to do so. It cannot say exactly what we are to do. It indicates the boundary conditions, what to do and what not to do, so that it fits within the limits of approval of the European Court of Human Rights and the European Court of Justice. So we need to develop our own set of concepts, our own framework, and either it will be approved or not. And we need to relinquish our pride. I say this to NGO chair people. Even if you've made a project, you've done a project that you're proud of, because there's no need to insist to cling when we know that it won't be approved. Policy is only as effective as the goals it sets out to achieve. Optimizing the road that we need to travel. I know I could say more, but let me say one final thing. So let me say one thing. The slogan Wehrhaft. So I believe that it's a very rational, reasonable claim, idea, but we need to understand what we have to do. We need to reach into all of our reserves and our talent in order to interpret from goal to means, and this is a systemic type of interpretation. So let me give you one example, and that will be all. It's a very good example. Respectable lawyers whom I respect, one of them criticizing, or two who are criticizing the solutions currently being debated, wrongly, I believe, at least in one case. So when it comes to remedial action in the media, ownership instruments were employed. There were so many people saying it's wrong to do. However, it still fits within the limits in my view. There was so much resistance in a recent case as well, involving the Prime Minister revoking counter-signatures. However, if you're familiar with administrative procedure, you will know that this fits within the limits of administrative process. If we assume that counter-signature is an administrative act and a way to proceduralize the procedure employed by the Prime Minister, I think that is the right road to impose a procedural framework on even high-ranking officials. It's not unreasonable. So an institution, an instrument to self-correct. Of course, that was taken to the provincial administrative court. The provincial court took what they wrote verbatim in the memo from the president and said, not doable. This is a ratione imperi ruling. I disagree, but I have to accept it. Okay, we'll see what happens. So I believe that it was a good thing that it went to testing. I'm a proponent of testing because something could be interpreted out of it yet. However, our democracy, our rule of law, will only be as wise as those that put it to use. Thank you.
Thank you very much, Professor. And now, Professor, in keeping with the order, I wanted to start the discussion as regards the counter-signature, because it so unfortunately happens, and this is partly my fault. We have 5 lawyers here, and we're not helping with this process, the process of clearly describing how the process should go, but the minister has also reminded us that democracy is about differences of opinion, because there were shortcomings in rule of law prior to 2015, obviously, and it's not the case that It was a land of milk and rule of law prior to 2015. Milk, honey, and rule of law. But I don't want the issues of challenging the counter signature, but court rulings as part of public debate, I'm sure they can be challenged, questioned, criticized. Constructive criticism is helpful. And it's like the academics whom the professor mentioned. Thank you. Thank you for having me. Professor Eva Wintowska set the direction, and I'll begin by referring to the metaphor, what she said about hats. I wear only one hat. I wear the hat of an academic and expert, more of an academic, in fact, and I will try to stay in this hat throughout my intervention. And this also defines the narrative that I need to take up. I want to refer to what the professor said about method, and what Krzysztof Debski mentioned about the debate, the discussion on rule of law and the method of restoring rule of law. My comment is, and this might sound banal, but it's something that needs to be said. Restoration of rule of law is not a simple matter. Yes, but it's worth saying that, making that explicit. So it's no wonder that even among academics there are disputes as to how rule of law is to be restored. Before the parliamentary majority changed, or even before the 2023 elections, there had been discussions among us, among scholars of law, jurists, constitutionalists, and other lawyers, how rule of law should be restored. And let me say that there was no consensus, there was no single answer. There were two sides, one could say. One side which supported a radical approach, a pro-binary scenarios, whereby a fast track scenario. There was another side which called for nuance, evolution, which of course involves protracting the process in time and many changes. And as the minister, I believe, said, it's an equation with many variables. So we know that the second option was chosen for various reasons, and this second option, this second procedure, we're currently discussing how effective it is. We're looking at what succeeded, where it didn't. Academics have a tendency to examine the formal aspect, but I believe that this is something we should avoid. Yes, just as the professor said, the law is multifaceted, and we cannot merely consider the formal aspects. We also need to consider rule of law more broadly, and that's the purpose of today's meeting, I believe, of today's conference. And the purpose is to take into account the social aspect, the political dimension, and indicate that as in all these it is within these facets, these various aspects, that we must work, and we must find a way of connecting these dimensions so we understand one another, because you have experts and then you have citizens. So as experts we can say this is the only way to go, but I fully understand people in this room who ask questions, who want to know why a certain matter hasn't been addressed yet. So that's by way of an introduction. The method for restoring rule of law is not simple, obviously. Now, as regards what we're aiming at. what we're not aiming at. We certainly do not want a restoration of business as usual, of status quo ante, because it was by no means perfect. And I fully agree with what Professor Wentostra said. There is no ideal. The ideal is a theoretical concept. It's an academic utopia that hasn't been realized in practice, hasn't been implemented. There will always be setbacks, and we need to set a direction. And I also believe that we need to make it clear that the process will not be possible without stumbling blocks, without tacking, without avoiding veering between. It's like a minesweeper. The minister said that it's okay that the minister wears a different hat. I wear a hat. A hat that should be more objective, that should make me more objective, if I may say so. And it's obvious that many things did work out, many things have been accomplished. The things that were achieved successfully were those that were possible to address without legislative action, without changing the law. Why there haven't been legislative changes, I think there's no need for me to explain. However, it's a question of differences between the formal approach to rule of law and a more social approach. So from a formal position, you can say that it's not possible at this time, but in terms of the expectations of the public, of public expectations, there's some impatience. Why hasn't this been done yet? Why haven't these changes been introduced? And I think this is a challenge for the Ministry of Justice and for the entire coalition. It's also an element that I think we're lacking in today's debate on restoration of rule of law, namely communicating a rule of law to the public, as explaining why and how, which way we want to go and which way we're headed. And finally, we've often mentioned rulings and verdicts of European courts, judgments, as well as opinions of the Venice Commission, and indicating that the Venice Commission shook its head and said that some things will not be acceptable, some things that seemed acceptable, that had seemed acceptable to us. But the change, as we see it, the radical change compared to the previous government, is that we're accepting this criticism, we're hearing this criticism, and trying to adapt. So this is a dialogue, this is a form of dialogue between the domestic national authorities and international institutions. And as part of this dialogue, we should try and work out solutions that will be acceptable and effective. Thank you. Thank you. This was also an important thing, what you said about language, communication, and what we're saying about what's being said about the Venice Commission. Thank you for appreciating for the panelists. Yes, but in terms of language, the minister didn't say that. We'll be saying more about that tomorrow, because we also notice that this is a very important matter, the question of language. And a lot has changed in the context also of the language used by the Minister of Justice, which is so different from the way the previous ministers spoke. Their vocabulary, their language in terms of standards, in terms of their referring to international standards. President, Justice, and President and Mr. Chairman, because we've got of the Chairman of the Codification Committee, which also has a role which reviews, but is also an active actor, an active participant in the changes. The professor said, I'm taking this out of context, but she said that if you write regulations, everything will be hunky-dory. everything will be okay. I see this as an expression of trust that this is sufficient. Mr. Markiewicz, which way is the road? Which way is this work on rule of law headed? I want to ask about the proceedings of your committee and its effects. Christian Markiewicz. Thank you. Some 2 years ago, I remember during an evening meeting, some sort of official ceremony, I was talking to a colleague from the Supreme Court, and they told me that they did everything that was possible. This was also said today in the context of the minister, whom I greatly respect. But it's not you never did everything you could. That's the way I see it. And this year, we haven't been able to achieve everything. Speaking of tacking, of sailing, of changing course, there's also the question of speed, velocity, direction, and so on, pitch, yaw, whatever. But it's also, and also, Krzysztof, it's what you said as you said at the beginning, Krzysztof, what I was missing is, and not just myself, but at the beginning, I missed specific goals. Consequently, for several months, we didn't really know which way we were going, what the purpose was, the objective was. You can have various instruments, various views, various ideas of how goals ought to be accomplished, but this is something we had a problem with from the beginning. Some things became clear 3 months ago, 4 months ago. Shame it didn't happen earlier, but tough. It's water, but time did pass, and we need to realize that this is it's November 2024, and you also need to be able to calculate that over a quarter of the term of office is over. It doesn't really matter, because when the elections come, nobody will ask when the government was appointed. So it's a quarter of the term. This goal wasn't clearly defined. It was sometimes occluded. But when the goal was defined, the minister mentioned 2 resolutions of the parliament on the NCJ and the Constitutional Court. These resolutions weren't that precise. The minister said that he was hoping that the National Council of the Judiciary would be wound down. I suppose we were all hoping that it would be dissolved or it would be suspended, that the process would be terminated, that the competitions to appoint neo-judges, that disciplinary advocates would be removed from office. But no, the National Council of the Judiciary is continuing to operate effectively. These disciplinary officers are still holding conferences and making charges. But the reason I'm saying this, and also Maciej Nowicki, you mentioned this at the beginning, we have a problem with communication. It's something that's difficult, that's a problem not just for judges. I was in a taxi today. The taxi driver said, when will things change? What's it all about? So whoever I talk to, and I really don't. So I traveled the country. I don't just. I talk to all sorts of people and all over the country, and I try. So we have chaos in terms of information and communication. Simple example from 2 days back. On Tuesday, my codification committee was in session, and I was also informed that there is a session of the parliamentary committee on codification, with the chairman of which is Marek Sakan and his colleagues. So who's representing the Supreme Court? Neo-judge Misztal Konecka, and Professor Krajewski. So I'm getting a lot of text messages asking what this is about from the members of the committee as well. But there's a problem with communication here, because on the one hand, we're saying that we've adopted a resolution to the effect that the NCJ is bad and can't continue working, but it's still operating and nobody's protesting. We're saying that the Supreme Court isn't okay, neo-judges aren't okay, and the counter-signature, this is the only government document in which the Prime Minister clearly says what he thinks about neo-judges and the Supreme Court, but the same person who doesn't have a counter-signature comes to the Parliament of the Republic and represents the Supreme Court. So we're saying that there's no NCJ, the NCJ is unlawful, and the chair of the NCJ comes to report. This doesn't require statutory changes. The president is not an obstacle here. It's a question of not legislative level, but doing what can be done here and now. And here I disagree with you, Professor, that I'm addressing my colleague, my professor. I disagree. Actually, there's a lot that can still be done in terms of internal communication. We had our colleague, Minister Professor Adam Bodnar, whom we respect and whom we like, but he's not the only one responsible for the way we see politics, for the way we see the legislative and executive branch. I have a problem with, for instance, what's happening in Parliament when it comes to the relations, or is the Chamber of Extraordinary Control in the Supreme Court, is it valid or not? Do we take the ECJ judgments seriously or not on the disciplinary chamber of the Supreme Court? So now, a year in, perhaps we should have some sort of uniform, coherent internal and external communication. It's not that difficult. It's not so hard to reconcile that among 10, to have a common front, if you will, among 10 institutions or 10 individuals. And so second, I greatly appreciate, I'm very much, yes, there is a need to talk, to debate, to discuss, and differences of opinion. Actually, here we're doing quite well because we can differ, but there comes a time when you need to resolve a dispute. It's not about carrying on the discussion forever, otherwise the state will collapse. The state will... I might be wearing the hat of a professor, but above all, my hat is the hat of a judge, and I continue to rule. I don't know. I'm still an active judge. Anyway, it's not, I don't find it very... So what I see, I continue to be an active judge on the bench with the same caseload I had 10, 15 years ago. And it's not a small court. It's one of the largest courts in Poland. So I gladly, but that's not the point. The point is that the situation in courts isn't rosy. It's getting more difficult, in fact, and it's also that there are no prospects. There are no prospects. And nobody knows which way, what will happen a year or 3 down the road. Given a variance A or B. So that's what interests people. That's what people care about, whether they will have access to justice, whether they will be able to have their case heard efficiently. If I hear that there's a backlog of 6,000 cases in an appellate court, that's a problem. So until the Minister of Justice supervises courts, he is responsible for that administrative supervision. I'm wrapping up. And also just a few words about the committee, the codification committee. As the minister, I mean, the conclusions that you can draw from what the minister said is that he's doing a lot. There's a lot he's doing, but this also shows that we need to consider whether one institution should be responsible for this whole range of issues. The prosecutor's office, the prosecution service, which is a priority, the judiciary, another extensive area that needs. The office of the Minister of Justice is also huge, so perhaps we need to consider how to efficiently organize the state in this area. And my penultimate comment, we are in a difficult position, as Maciej Nowicki said. I'm in touch with other justices, judges, prosecutors associations in Europe, and the situation is indeed very difficult. I wonder, it's surprising that we were able to get the attention of Europe to our problems last year, in these recent years, because the general situation is difficult. So we will be all held to account, the Codification Committee, and we will be responsible to present solutions that we believe are the best. We have no problems. We will try and develop instruments that are constitutional, that also comply with the judgments of European courts, and importantly, we want to survive the entire process. We don't want to create an ideal tool that will be the downfall of this system within 2 years or 3. As for the committee, there is one draft ready by the end of October. The Venice Commission is abstract, and they're stressing that it's an abstract opinion. But it's still very important. It's still very relevant. We are introducing the changes mentioned by the minister, and we are in touch. We're in contact with the ministry. I don't want to take them by surprise with any. So anyway, the draft should be ready by the end of the year, and the opinions, the justification for that, you need a few more weeks to have a coherent. It's not simple. Also, in terms of regulation of status, the two chambers of it provides for two chambers, and also the elimination of extraordinary appeal. There's also Justice Olbrzymska who's working on this issue on administrative courts. It's very complex indeed. But I also hope that they'll do everything to make it the best possible. We're working in an extraordinary. We're working with expedience to make sure that. There are also drafts on secondment, which were submitted by the ministry. There's the question of liability, accountability of judges and prosecutors. There's the act on the prosecutor's service. There's also the act on the NCJ, which is currently being heard, which has been referred to the Constitutional Court. So generally, I don't know. There's a lot of work being done. Yes, thank you very much. And speaking of the prosecutor's service and Minister Bodnar, Minister Bodnar, who also wears numerous hats. He's also Prosecutor General. He was a senator, and again in the prosecution service, there's work being done to split Prosecutor General and Minister of Justice, these functions. And I won't comment on these remarks. I'll hand it over to Maciej Nowicki, who a social lobbyist, or a lobbyist for a cause, but also someone who's deeply engaged in international dialogue. We spoke about the role of international organizations in establishing standards on how it all should operate. Of course, it's not one size fits all, and the whole challenge is to adapt it to Polish circumstances, which are very complex, as we've already seen. But yes, let's have the perspective of the Helsinki foundation, the foundation which is voice, which is a reviewer in this debate, which is a watchdog, which makes sure, which works for the cause. And so please, if you're prepared to comment on what the minister said, what was absent, what was missing. And just, there will be questions in a moment.
Bardzo dziękuję. Bardzo wiele.
Thank you so much. A lot of important things were said by my predecessors. So I'm going to allude to those, to respond to those, not just the minister. But let me start by differentiating between the different levels and different problems that we are up against when talking about rebuilding rule of law in Poland. So on the political level or the socio-political level, what has been channeling our attention at the foundation, but also in many other NGOs and civic movements, like Citizens of the Republic, whom we've been talking to on a regular basis. It's the connection between rebuilding rule of law and the risks associated with the deep socio-political polarization that we have. If we look from a broader comparative perspective, when we look at the experience of countries that emerged from all sorts of soft authoritarianism, systemic infringement of rule of law, and tried to rebuild those values, then we see very clearly that without a minimum level of consensus, without minimum consensus over and above political polarization, this process will not come to fruition in the long term. So if we are looking at the coming years, we see this as a threat, a phenomenon that has been described as a spiral of judicial reform. So we do one thing, then the other political option does another thing. For instance, Argentina was in such a spiral, and those judiciary reforms lasted ad infinitum. They were able to break it, but it's very dangerous. So in our present political situation, are we able to overcome political polarization? I would be very cautious. I would be very moderately optimistic. However, I don't see a strong role here for NGOs. However, at the level of working with different milieus, with different groups, but also working with society as such, making certain depolarization efforts, even though this sounds utopian. However, it seems indispensable, and we want to make such efforts also in the judges' community, because in every solution, including the one we've always been a proponent of, the one proposed by Justitia, most of the judges appointed after March 2018 will remain in the judiciary. It is already a very difficult situation between old and new judges. So we need to establish the minimum socio-political, psychological conditions for any dialogue to be able to proceed. Perhaps on the communication level, there is a chance in the attempt to differentiate two important and interrelated, however still different, aspects of rebuilding rule of law, namely accountability for what happened and building truly independent institutions. So the second option, and that is really at the core of rebuilding rule of law, perhaps the second aspect is less polarizing, and we can truly present it as trying to build institutions that are independent of this power, of that power, and of any future power. I know that this is difficult terrain. It's almost utopian. 5 years ago, I would never have expected, as somebody who is such a realist, that I would be saying this. However, there's no other way. If we truly want to lay the foundations for a certain understanding of rule of law as the minimum rules of the game that is respected by everyone, and to minimize a risk that the next the opposition will come into power, turn the table over, and everything will have to start anew. They'll start everything anew. So on the legal level, one thing I was missing in Bodnar's speech is that what's missing, it's not just communication, but embracing a clear set of assumptions regarding the foundational problems that but there was an action plan sent to the Commission. However, as you know, Krzysiek, the action plan merely said, okay, we'll do a law on the Supreme Court. We'll do a law on whatever it's needed. But it didn't talk about the basic theoretical assumptions and how we're going to deal with the problem with the status of the so-called neo-judges, their rulings, plus the rulings of the Constitutional Court issued in a double set of judges, by a double set of judges. Or by two ruling bodies. So there are too little deep, reliable analyses in the Polish legal context on this. We previously talked about what it means to invalidate, to overturn a ruling, and what that means. There are discussions on Twitter, but that's only skin deep. When it comes to the political problem, the lack of basic assumptions, that would set the standard of communication so that we know what we can tell people who really do come to the Helsinki Foundation and ask, is my ruling going to be overturned or not? And we don't know this. We need to be honest. It's an unknown. But we also need to say that one part of rule of law, just as important as the right to justice, established by law, the right to an independent tribunal, is the certainty of law, and most of the rulings will be maintained rather than overturned. And this is something we all agree on. That is the message we should be sending out. Not all statements, including those by Minister Bodnar, who's saying that the law on the Supreme Court does not exist. There's no such law. Okay, we'll get into this. I'll hand it over to Professor Wentowska in the first response round. I also think it exists. One exists. So if the minister says it doesn't, that's very arbitrary, and it is cause for concern. It creates distress. Whereas the minister should be have reserve in making such statements. Very briefly. Another thing we're missing is preparation, groundwork for reforms. We know we have 6 months before the presidentials, and we need to use that time to do it well, to do all the consultations, to create a package of reforms. The Commission is working. There will be a consultation process, but we need to assess the consequences ex ante, so before these laws enter into force. So I'm worried when I hear public statements by the ministry. I read this yesterday. The ministry is assessing the neo-judges. It has just assessed their number. We should know the exact number a year after the parliamentary elections. We need a map of the judiciary in Poland. Where are these judges? What departments? Only then can we develop solutions, because we'll know what it means for everybody to go back to their previous positions. We'll know what it means for the system and its functioning. The system, the right to legal recourse and to due process, that may collapse. I know that Judge Verboda is working on this. You're working. That's great. However, a year in, you're estimating? Well, Minister Mazur yesterday said we're estimating that. No, they have the exact number. That's wonderful. I will gladly give the floor over to Judge Wentowska, because it's going to be an interesting filler in. So I'm just saying what the ministry is saying publicly. The Venice Commission and the ODIHR, not just the Venice Commission, also the ODIHR. I'm drawing your attention to very important opinions on the law, on the Constitutional Court. One of them is positive, saying what the court is to look like. The other one, which says what's going to happen with the rulings issued wrongly. That's critical. We're waiting for the opinion from Venice on December 6th. So the two top theoretical problems. We don't really know what direction we're going to go. Maybe we'll have to do more work, a lot of work. The Venice Commission and the practical level. You can agree or disagree. It is a practice in Strasbourg. if the Commission waves a red flag, the Strasbourg Tribunal will find an infringement. So we need to respect what the Commission says, what ODIHR says. Moreover, our reform process should follow international standards. And we used to be so attached back in 2017, also the Helsinki Foundation, when the Venice Commission made its first proclamations regarding Poland. So I wouldn't neglect their opinion, but also bona fide. So you're also wearing the hat of a co-organizer of the conference. This is really the end. My last two sentences. So we need to meet the Commission's requirements in good faith. There is a concern. So I'm hearing that 2 or 3 groups of judges will remain. One will have to go back to their previous positions. One won't. The Commission said it has to be an individual case evaluation. So we're not going to make a law that says what is going to happen to what group of judges. We need to evaluate on a case-by-case basis. But again, we'll be losing time if we pretend that the basics required by the Venice Commission is only a recommendation. Regarding the Polish-Belarusian border, we have mixed we have provisions at odds with European law, even though they're not impacting reality that much. We had pushbacks pre and post. It also shows how complicated, how large the scope, a scope there is to rule of law. Independent institutions, this is something I've been looking at for many years. Perhaps a bit naively previously, we'll be having a panel to that effect tomorrow, what it means to be independent, because I think in recent years a lot of our ideas were overturned. So maybe 3 minutes just to respond to what was said and leave some time for the audience. One thing that I was missing in the minister's response to a question from the room about a possible plan B, because we seem to be waiting till the presidential elections. That's just around the corner. We have different political dynamics. So what about this plan B? So in order, plan B, we'll need to start from scratch. We'll need to retrace our steps and start from the beginning, depending on the circumstances, and then we'll see. We'll wait and see. So I apologize that there's no plan B to be made in advance ahead of the presidential elections. Another thing. All of us, we have a discourse on rule of law which has become a weapon in the political fight. And moreover, we're looking at future elections where rule of law will have a different meaning, constitutionality will have a different meaning, the choice of specific dogmatic tools, etc. Another thing that we're failing to appreciate, we are all on social media in some way. It is just a load of poison. It also manipulates our own assessments and judgments. One thing that I would correct, it's not just an issue of having an idea on how to communicate. We need to have a strategic idea. The ministry needs to have a strategy, the Ministry of Justice, because I'm not seeing one thing in place. Working with staff, working on their awareness, because we won't make any progress if we don't do that. We mentioned working with prosecutors. Of course, they need to unlearn that if they have a success on their count, they sell it to the media. Ahead of time, it's working with judges. It's a population, a community that's hurting, that nobody is talking to, nobody is working with, nobody is giving them clear prospects. We keep hearing about calling people to account. Of course, that's necessary. However, we also need to be giving a positive message, because in the Supreme Court, as far as I've been following, we have 5 survival strategies. They're all disjunct. And at the end, those who suffer are those who cancel rulings, who challenge rulings, and also how to talk to society. I have no hope of convincing anyone to side with my conclusions on different kinds of rulings that have been overturned or have been invalidated. I'm not trying to sell it to anyone. However, I think this is the remedy. This is the cure. But there's one thing that we can sell. If we have a true success, even a small one, if we're selling it, make it into a mixed bouquet. In any strategy, address the positives, those that have bearing on people's lives, because I don't have an answer. I don't think anyone has a remedy, a recipe for how to get the public, broadly speaking, involved or interested in rule of law discussions. It's truly the salt of the earth of their daily lives, the air they breathe. And here, I think it's here that we need to do work on raising awareness. Bureaucratic security, that's...
Dobrze, dziękuję.
Okay, thank you very much, and I will now comment on 3 matters, the first of which is the lack of a communications strategy, a consistent communications strategy, and I fully agree with what's been said, but it's not simple. Why? Because currently we're dealing with Schrödinger's cat, which exists and doesn't exist. The institution exists, but it doesn't. So the NCJ does, in fact, exist. It operates, it issues decisions, it nominates, it issues decisions and adopts resolutions, but now we're saying that it doesn't exist, that it's a National Council of the Judiciary, that it's politicized, and so on. And this is the case with other institutions and individuals who are in positions of authority. So what do we do as an academic, as an expert? I can say that norms and standards are one thing, and facts and reality are another, political facts. But that's not necessarily convincing. That's not something that the general public will appreciate. The only objective, the only goal we can set ourselves is to have a communication strategy that accounts for this lack of consistency. But this would be very difficult, and I'm aware of that. The second matter, on international standards, I believe that there is that it's one of the assets, one of the positive elements of the last few years. I'm also referring to those years where rule of law was glaringly, blatantly violated in Poland, was that our attention turned towards international institutions, towards European courts. So let's appreciate the fact that we've noticed them and that we're now engaging with them openly. It's not an easy dialogue. Strasbourg speaks a different language than Luxembourg does. And of course, depending on the procedure, it applies, whether it's a request for preliminary rulings or complaints procedures or applications. Again, it's really applications. It's not something that's easily explained to laymen, not even lawyers. Even lawyers have a problem. Sometimes when I'm trying to follow academic discussions on the implementation of these judgments, it turns out that every professor has their own interpretation. I'm not saying that the law is relative, because it isn't. However, it is very difficult to understand and to find the essence, the gist of the substance of the standard. Sometimes that needs communication at various levels, and again, it's like Professor Markiewicz said, time is of the essence, and perhaps we might run out of time. One last issue is that has to do with Plan B. Plan B. I agree with Professor Wentowska. There is no Plan B at the moment, and I think there can be no Plan B at this stage, because at the moment we cannot anticipate, we can't predict what will happen in a few months. I'm not referring to the outcome of the elections, the formal outcome, but I'm also referring to social attitudes, political communication. And also on communications, to close, I wonder to what extent we can look to transitional justice and theories of transitional justice. I really don't see any direct relevance, but especially when it comes to holding to accountability, one thing that can provide some kind of indirect inspiration is this attempt to find dialogue to engage people who are on the opposite side of the barricade. If we are to survive as a society, this dialogue will be necessary. Even if it proves difficult, it will be necessary. So first of all, it needs to be emphasized that something happened to which we're no longer accustomed. We've actually that the Minister of Justice has come to speak to us. So looking back at 30 years of Justitia, there was an 8-year period where we weren't able to speak to the minister, and now this dialogue has been reestablished, which is a lot. And now we have a system that's very shaky indeed. We have a condition of uncertainty, a state of uncertainty, insecurity. People want to be hugged, literally. People want someone to come and say what they want. Believe me, I talk to neo-judges, and they tell me, but they want to know what's going to happen. It's not that neo-judges are our enemies. That's 3,000 judges we're talking about. They're very diverse as a group. So and these people, as a matter of principle, will stay within the judiciary, and I have no doubt that we need to engage with them. This dialogue is necessary. We need this dialogue. In the association of which I am president, we have many neo-judges, and this is a huge challenge, a challenge we need to deal with. All these people, everyone is waiting for a decision, for a decision to be made. How long do we keep talking? How long will we keep talking before we start the change that people are waiting for? People really aren't too concerned by the discussion on neo-judges, although this is a problem that people are seeing. But once they live to see a judgment being passed, they want to know whether that judgment will be enforced. How long will they have to wait for the date to be set for a hearing? On non-existent rulings, so we need to decide. It'll never be binary. You'll have to decide one way or another on whether these rulings are deemed non-existent. So the question, where is the law, where is the state? I want to refer to a lecture by Professor Safian when he was granting an honorary doctorate at the University of Silesia. So it's normal that the law and politics sometimes overlap in terms of trajectories. But what the professor said is that changes, the boundaries are to be set by the law with a capital L, not with a lowercase l. And so we need. So as for Plan B, I think Plan B is something we should be working on now because this is where we are. We don't have a president signing legislation. So how will this differ from the situation a few months down the line? I think that this Plan B should be put into effect now instead of waiting for the election in May or June and thinking what ought to be done, because then we'll have lost several months, which we don't have. Briefly, one thing I was missing, but it's actually a good thing, Minister Bodnar didn't talk about a lot of positive things, positive changes, including something we were lobbying for ourselves, and we wanted the Venice Commission to be given abstract questions, and the ministry is taking this into account, which is extraordinary. And I also think that what you said, Christian, that for the people it matters more if they have access to justice, if they get their case heard in a reasonable time period. So reforming court-appointed experts and digitization as well. Two weeks ago, they announced a digitization process. This is very important and very in terms of social support. And let me just comment one thing I was missing. Christian said that we're doing well with this dialogue. The difference between us is substantive, is one of substance. It's really important when it comes to the status of neo-judges. But this dialogue, apart from official dialogue, was frank. It's frank and ongoing. And I hope that it will continue, because we have a similar definition of the problem, of the causes of the problem. We have a similar purpose. We want these basic problems to be addressed in a systemic way. We differ in terms of methods, but both parties have called for and are continuing to call for a structural, comprehensive, systemic approach to this problem. And I think that in the public sphere and public statements, you have 3,600 judges. Very many things have been said. Many things have been said by different people. But I also want you to know that NGOs, despite our differences, can talk to one another. But just for a grain of salt, or to a fly in the ointment, one thing I missed, Professor Wentowska is an exception here, when you have them leading the judges who have stood up for rule of law, our colleagues and our heroes. And I'm not being manipulative. When judges say things that should be criticized in public, but these things are said in silence, deafening silence. Yes, I'm referring to someone said, well, Poland will lose in Strasbourg. Too bad. We'll pay that compensation. So this is a judge speaking. We will have abused the human rights, and we don't see this as a problem. And another quote, rule of law needs to be restored using the methods with which it was violated. It was violated by a violation of the Constitution. And this quote, this statement, was not sufficiently criticized by ourselves and by society. Yes, thank you. Now for a Q&A session. Let's have 3 or 4 questions. So let's have the microphone, and please. We started 5 minutes, so let's conclude at 1:05 p.m. at 1:05. I see several questions. There will be a longer lunch break. We'll have time to discuss matters informally. And now, Justice, yes, Judge, I'll thank you. If you could possibly introduce yourself. Marta Korzuchowska-Warywoda, I'm a judge, but currently I'm the director of the Department of Personnel at the Ministry of Justice. The number is changing, but we are keeping track of the numbers. We're fortunate that the personnel programs at the ministry are more modern than the software for court secretariats, and I deplore that, but it's regrettable. Now, the question on the access to this is data that's available to the directors and presidents of courts, so we have a problem in providing this data as public information, but we're working on legislative changes. We are talking about 3,130 judges. So this is a group of individuals who, specifically 3,142 as at the end of October, one of which 1,071 are considered to be rookies, young judges who were applied in the NCJ, but this is not judgmental. So they passed their judges' exams. These are assistant judges and referendaries who passed their exams. These the relevant group, the group who were promoted, is 1,130 individuals. So in terms of organization of the judiciary, they are indispensable. If these persons stopped being judges, then the efficiency of the procedures, then it would be a dramatic situation. So we need to find a solution, and it's been discussed for some time, to allow these judges to remedy to restore their status. Those who didn't detract from the dignity of the office, who didn't take part in the process of corrupting the rule of law. So these are judges who need simply to sort out their situation so that they're no longer accused of being neo-judges. Their status needs to be simply rectified somehow. And the most difficult group, 330, are those who joined the judiciary following a competition, or from the outside, a competition organized by the improperly composed National Council of the Judiciary. And it's a question of evaluating, of defining their status so as not to leave them stranded entirely if they had not actively contributed to undermining rule of law. And this is something we've been doing for the past few months. And to comment on what Professor Markiewicz said, we're also considering how to strengthen the courts and using assistant judges. We're talking to the Minister of Finance on the budget and on providing more positions on paper. The number of providing more personnel for judges and in regional courts. This because they're lacking assistance in the lowest courts. But until we have a budget that's been approved and signed, I will be cautious. Thank you very much.
Właśnie tylko prosimy o krótkie, bo tutaj już...
Thank you very much, and please be brief. I understand brief, but I'm here as a citizen. I'm just saying because as citizens we have to agree to a framework, so that is why the request. I would like to address my wonderful, beloved Professor Łętowska. I wanted to explain. You said I had given Mr. Bodnar 2 hats. I'm a little stressed now. I wasn't talking about 2 hats. I was saying that we as society, we will never forget that Mr. Bodnar was the ombudsman, and that is all I wanted to say. And that we are counting on him, that when legislating he's going to make a just law, a fair law, thinking of putting citizens first, humanitarian and simply human and humane. I just wanted to explain myself. I wanted to explain what I meant. With regard to legal issues, over those 8 years, citizens also read up. Please don't treat us like idiots. We understand what you're saying to us. We understand what you're saying, and I want to emphasize that. And it's not true that the communications are bad. You have to make sure that you're actually talking to us. It's that simple. And the third thing I want to say, and I also have the right to say it, citizens totally cannot understand why the rulings of the European Court of Human Rights, the ECJ, the CJEU, and the resolutions of the same, why they're not being enforced. It's on these judgments that rule of law is based. It's from them that it derives. Why are they not being enforced? We have the right to lean on these judgments. So if a neo-judge comes to a parliamentary commission, you know what I'm talking about, a neo-judge, it's a scandal. He shouldn't be there. This person shouldn't be there. That's what I have to say. And citizens do understand that. Thank you so much for that opinion. I saw some hands raised at the back. Aleksandra Wrześniewska-Nowacka today wearing the hat of the chairwoman of the Polish Association of Administrative Judges. So after Mr. Nowicki's statement, I'm very happy what he's saying about the need for NGOs to start depolarizing society and how depolarization impacts how people see rule of law. I only want to ask, how do we do this in a situation where we need to learn dialogue? We talked a lot about dialogue. In the Codification Commission, we are continually in dialogue. We are in dispute, but we put forward legal arguments. The situation at present is like the T-Mobile commercial. There's a glass wall between two girls. We have a glass wall in between, but there's nobody willing to take a brick and break that wall. Everybody is just talking about their own arguments, but they are sealed off. Their ears are closed to the arguments of the other side. So I think depolarization should start with restoring the meaning to the word dialogue and the ability to converse, not just to throw arguments around and call people stupid, as often happens, but merit-based arguments. And what I really liked, maybe our colleagues didn't after the new NCJ, they probably wouldn't like it, what the judge said about the fifth column. Until we deal with this, and like what Mrs. Varevoda said, that these are great judges, only they've been through the NCJ, but they didn't destroy rule of law. I apologize. If nobody had gone to the KRS, if nobody had nominated these people to the NCJ, if nobody had tried to get a promotion, I wrote an article on this. At some point, my emotions overflowed. It's a different viewpoint. If I, as a citizen, go to court and I have a judge who's very knowledgeable, professional, they know their stuff, but they realize that sometimes putting that knowledge into action requires courage and might expose them to unpleasant consequences. How would I feel? So this judge understands rulings of the ECHR, the ECJ, the CJEU. They get nominated through the new NCJ. Will they have courage in my case when they have to make an unpopular decision? So for me, the fundamental issue is restoring the ethics of judges, and we can't do it if we keep protecting neo-judges. There are voices like this in public debates saying, oh, nothing bad, nothing happened, it's okay, it's all okay. I know my statement is perhaps emotional, but without restoring meaning to the service of the judiciary, because we are a service, we are servants of the law for the sake of citizens. So we can't do anything if we don't deal with this issue, even if we make reforms. It's important in the here and now. We can do this without passing laws and without the president. And I see somebody at the very back of the room. Maybe we'll take that question as our last. Barbara Grabowska-Moros. I wanted to ask about one of my favorite institutions, the Institute of Justice. It's been a year. We were almost able to count how many neo-judges there are, but the body that measures and names the problems of the judiciary is this Institute of Justice, a research institute. Is the Commission planning to ask the IWS, the Institute of Justice, or to commission research, say to measure or to assess the status of neo-judges, not in legal terms, but in sociological terms? Why are 1,100 judges, why did they decide to run for positions before the NCJ, a politicized NCJ? And secondly, a recent message was published on the site of the Parliamentary Assembly of the Council of Europe, just after a visit to Poland. Poland is still being monitored by the Parliamentary Assembly, and in this very brief press message, they emphasized not just polarization in Poland, but also polarization among judges. And it's hard for me to recall another such press communique where polarization would be at stake. So my question is, within the framework of the proposed legal changes, how can we defuse this problem of polarization? Yesterday there was a webinar on Wałęsa's, in the case of Wałęsa against Poland. One of the arguments raised was that the new NCJ, the newest one, is supposed to be independent of judges as well. How do we make that happen, however? So December's around the corner. Let's extend the panel to 10 past. Christmas, with Christmas around the corner. I'm sure you have a lot of responses to make and give a chance to the other panelists. So I have very little to say because most of the questions were addressed to specific panelists. If we could raise the volume. So thank you, Basia, for mentioning that press communique. I will have the honor, along with Professor Bodnar, of taking part in a hearing next Monday in Tirana. And it's highly unlikely that the monitoring procedure will be closed. That procedure will be continued. We must keep in mind that Europe is watching. We do have trust, but it's not unlimited, and how the standards are met and implemented in our reforms, that will be followed very closely, including by the Parliamentary Assembly of the Council of Europe. So, as per the question on how to start a dialogue, we're not experts in that respect, but there's a whole group of NGOs working on it. There's Pole Dialogu, there's Stocznia Shipyard, where we are expanding that field. We need social psychologists on board. We need mediators. And I believe that it's also important that different institutions, as Paweł Kasprzak pointed out, they're also, i.e. citizens, they're also part of the process. These different formulas of participatory democracy, however utopian it sounds, they often bring the following result. If people are talking, not politicians, on the most divisive topics, then people with very different worldviews or with different points of departure, they can usually come to some agreement. With regard, say, to abortion in Ireland, it turned out that the turning point came with a civic panel composed of people from left to right. So I think that working with judges themselves first, checking the threshold conditions, naming the hurts, the harm that was done, because I totally understand the problem, the psychosocial problem, and the justice/moral problem, namely that the old judges might think, okay, we were faithful to our values, we didn't run for those positions, but the new judges, because they wanted to have a career, they were opportunists, and they did so. So now we're to run for higher positions and there to stay. I understand how this works psychologically, how demoralizing it is. And maybe we need to have that kind of dialogue then, to name it, to call it out once people start talking, to get confessions, admissions. It's a social process, a political process. It's not just purely legal, but the law is a remedy, and to ensure people's recourse to law, access to a court. But it's not about judges. It's not about you. However, we do have to deal with the judges, we as society, and that whole milieu as well. I'm sorry, this was long-winded. That's what happens when people say, I'll be brief. Okay, Professor Markiewicz, do talk long and be brief. I agree with what Maciek said. The law is there. It has a significance as well. Please note whether this was a civic initiative or the drafts that were processed by the Codification Committee. They're not based on the idea of calling to account. They don't mention disciplinary action, regret, etc. They only talk of taking into account the faultiness of the appointment process. And I think that's an important step. And we need to talk. We need to start talking. We need to wrap up the first stage. We need to move on. We need to open up the judges' self-government so that we have room to talk. It sort of died a couple of years ago, but that process needs to be reopened. As for getting an idea of the situation, for the moment it's a dialogue between the Commission and the Ministry. I keep applying for those data because we want to know, and we want to make people sensitive to the consequences, potential consequences of whatever regulation is introduced, and we will use it, we will draw on it. A new director was appointed to the IWS a month ago, and we will certainly draw on the professionalism of the Institute of Justice. Thank you. The title of the conference is The Evolution of State and Law. So let me ask the following question once again. Where are we now? There is resistance to the violation of rule of law, both on the international level, the social level, the political. The stage we're currently in is we're wrapping up preparations, preparing a strategy. We're finishing coming up with proposals for specific changes, and we are on the eve of very important decisions. Hopefully they'll be made as soon as possible, but we want them to be as good as possible in terms of aligning with constitutional and international standards. What lies ahead is depolarization, the depolarization of society. I think that's our most difficult task. It should be a grassroots process, bottom up. However, maybe we should look for inspiration to reconciliation or truth commissions, so institutions whose aim is to get people talking and to get empathy from both sides so they understand each other. But that is all in its infancy. Dialogue is about one person talking, the other listening, then the other talking, and the first one listening. Sometimes they miss out on what they're saying, but we want equality. I needed the hats metaphor, and I'm thankful for that. You thought I was sort of getting on your case. I wasn't. Dialogue. This is a perfect example. That's what it's about. We need to avoid misunderstanding. That's the difficulty of dialogue, and that is the problem with the judges. In West Germany, after the war, people came to work, judges came to work, who had served the Nazis. I don't want to invoke the ad Hitlerum argument. However, the system must absorb the neo-judges. Those clinging to their hurts won't be able to work. There are all varieties of neo-judges. They come in all shapes and sizes. Sometimes it's not the law we need. Sometimes we need a certain tone. Sometimes it's somebody's lack of courtesy. Let's not put everyone in one basket. They shouldn't be in one basket. They can't be. We need to approach it on a case-by-case basis, individually. Moreover, I have quite a lot to say to my lawyer colleagues as to the advantages of legal dogmatism when it comes to solving specific problems that you're dealing with. I'm here to serve. I write, I speak, I can tell you where to go. It's not my purpose to make you content, to make you happy with my dogmatic speeches. Maybe there will be a chance for that as well. Thank you all very much. I think two things that sounded here before I let you leave for lunch and before I announce the next panel. This allegory of a waiting room where nobody likes to sit. We want the train to come. We want to get out. It's cold. There are no seats, and so on. However, to make life bearable in this waiting room, we need somebody to care for us, to set direction, to tell us what's coming, to give us information, saying there's a delay of however many minutes, but the train is coming and there will be room for everybody on the train. So we need to depolarize. That is extremely important, and I'm very happy that it came up in this conversation. I wasn't expecting it. I wasn't expecting us to go that way. It's a colossal change in the language that we're using, because I think we've all had enough. We're all sick of living in constant tension with constant divisions, strife. I could hit high C now. It's not just about rule of law, it's also about social resilience in a crisis, reacting to crises. We can always get along in the end, but speaking of social resilience, and this is important for the Batory Foundation, we need to talk about systemic solutions. It's not always a mass movement here and now, people going out on the streets, but laying the groundwork for the resilience system to work when needed. So we need to look after rule of law on a continuous basis. We need to nourish it like a Tamagotchi that you need to feed. You can't skip a meal or the creature dies. And there's no finish line because social expectations change. It's a shifting horizon. It's different now than how it was back in 2010, and only 14 years have passed. So I think that's it from me. I would like to encourage you to also come back after lunch. We have very interesting panels ahead. A panel that also issues from this discussion: how much populism is there in fighting populism? That's another thing that we can't escape, another topic we can't escape if we are talking about how to restore justice and rule of law. We will resume at 2 p.m. Applause for our panelists, and have a good lunch.
Afternoon. We'll be starting shortly, and we're waiting for people to join us now. People are still having coffee. I always admire Krzysztof for being more sonorous than I am using the microphone. Anyway, literally, we're fighting to be heard. Good afternoon. My name is Małgorzata Szulek. I'm a member of the board of the Helsinki Foundation, and it's my pleasure to welcome you to this session, to this panel, which is a challenge for two reasons. The first is that it comes directly after lunch, so I understand that your sugar levels are going up and your attention span is declining. And second, our topic is one that we could dedicate an entire conference to, and we barely have an hour, 10 minutes. I'm very happy to tackle this challenge, this topic. We have a wonderful group of speakers, panelists. Let me begin by introducing Marek Teichman, who's the Deputy Editor-in-Chief of Dziennik Gazeta Prawna. We have Dr. Barbara Brodzińska-Mirowska, who's a political scientist, a student, a researcher, scholar of political communication and the media. Dr. Magdalena Góra, who teaches at the Institute of European Studies at Jagiellonian University in Kraków. She specializes in the foreign policy of the European Union and policy making. And Dr. Ben Stanley, political scientist, a sociologist, whose research includes election behavior, political parties, and populism, whose research covers these topics. The title of this panel is How Much Populism Is There in the Fight Against Populism? This is not a neutral title. It does have a thesis, an argument, but I will perhaps be proven wrong by our panelists. When we were planning the conference, we concluded that it was impossible to address the challenges faced by the process of restoration of rule of law, re-democratization of social life without a deeper reflection on populism. I feel that since 2015 in Poland and since 2016 around the world, since the first Trump administration, and the Brexit referendum in the United Kingdom, the topic of populism has become a universal. If anything went wrong, we blame it on populism and increasingly on polarization. In the first round of questions or remarks, I would like to ask our panelists, and actually asked them two questions because they are inseparably connected. First of all, what is populism, and can you have politics without populism today? I don't know where to begin because nobody wants to take the floor. Ben, would you like to start? Yes, please. I can start. Let me say, apologies for my Polish, but I'll try and speak the best Polish I can. For me, populism is basically the simple proposal that politics is all about, that the corrupt elites are unlawfully governing the people. And so when we speak about populism, we need to distinguish populism from illiberalism and authoritarianism, because I think that populism is part of a continuum. First, politicians, as we saw in many countries in recent years, in Poland, in Hungary, and the US, we also see that populism is being used to delegitimize political opponents and pretend that that only we can serve the people after the political success, after being successful in Poland, Hungary, and a number of other countries where populists are or have been in power, we can now move on to illiberalism as a set of practices, which are meant to delegitimize political opponents from a position of power. And with time, illiberals become increasingly authoritarian in their practice. So populism today, currently, maybe a few years ago, I saw it differently when I started research into the issue. But now I see populism as the first step, as the beginning of a process of deliberalization, or the degeneration of the shifting of the democracy towards authoritarianism. Barbara, yes, I really want to comment on the populism. Good afternoon once again, and from a slightly different angle. I see it differently than Ben does, because I would see populism, for me, I see populism as a dichotomy. First of all, populism is a style of communication. It's a communication style. This is important because Małgorzata, not Marta, I have a sister named Marta, so this happens. Anyway, what's important is that it's becoming a catch-all phrase, populism, which I think involves some risks. That's why I'm saying that populism today, at least in my discipline, in social communications and media, is just a style of communication. It's a style of communication that people like because it's simple, because it's based on emotions. It describes a complex world in a simple way, because it responds to a demand for a way of speaking about politics. And this style, this populist style, basically, isn't dangerous. It doesn't pose a danger for the system. But populism, which is ingrained, which leads to the undermining of democracy, is dangerous. Although, again, this is debatable, because we identify for several years now, there's a distinction into authoritarian populism, to distinguish populism, which had been seen as a natural part of politics. So populism was part of democracy, was where politicians listen to their voters, to the constituency, and try to respond to address their demands. Then there was competition for votes, for coverage, and politicians began speaking a language that the media liked, which led to the distinction into authoritarian populism and populism. So we have a dichotomy of us versus the establishment, a communication that invokes the emotions. And I see Marek and Magda responded, so maybe Magda would like to go first. I don't study populism, although actually today every political scientist must, in one way or another, address populism. However, I will not be challenging or questioning what Ben said and what Barbara said, but I just wanted to add that originally, in the initial debate about populism didn't have any ideology. It was a style of communication, but that didn't have any particular ideological potential, or actually it could cover the whole political spectrum, so especially the extremes of the spectrum. But what we're seeing, especially in Europe in recent years, is a conglomeration, is a connection of style and a political agenda with political views which cannot be seen, which cannot be considered non-ideological. On the contrary, Populism is becoming a way of following specific political agendas, which intend to change the political system, to overthrow democracy. And one thing that comes out in studies of populism is that it's the system in which populism emerges. In European tradition, we have various versions of liberal democracy, but it's largely based on representative democracy. And so I want to open up a space for Marek Teichmann. What populists are exploiting, is the rapidly changing, due to technological and media changes, the role of political intermediaries who had previously served to explain and who were gatekeepers, or in a way who were guardrails. So populists, on the one hand, populists essentially weakened all of these actors who kept from political parties through public opinion makers, the media, the religious organizations, congregations, and NGOs, as well as citizens. Populists are, because this wave of populism that's rolling over us, a wave that does carry an ideology. We're observing the fundamental erosion of representative democracy, and we're having a hard time coping with that. We're having a hard time reforming or fixing the system, because we keep thinking back to a status quo ante, and it's harder for us to imagine how this, because social media will stay with us, and how do we reinvent the system? That's also so, Marek, exactly what is the difference in relations between populism and post-politics, pop politics, and political entertainment? The professor mentioned institutions, organizations, and procedures which are being undermined by contemporary populism. And what is typical of that populism is that it's, as I see it, identity politics that creates a sense of identity based around challenging institutions and procedures, questioning them. In Europe and in the US, this sense of identity, a we who challenge these institutions, was something that sustained populists. And can we exist without populism? Because the essence of democracy, the essence of a discussion on what we're doing, on how we imagine our institutions, is to challenge these institutions, to question them. We should have tools in public debate to question how institutions operate, with a view to changing them, reforming them, adapting them to reality. But contemporary populism is destructive, is devastating. It's so powerful that its questioning of these institutions is destructive, destroys the state. To answer your second question, the question how much populism should there be in public debate, and is this reconcilable with the state or institutions and how they operate? Well, I feel that I think back to a text by Piotr Kwieciński during the early days of the Law and Justice Party, when more moderate members of that party felt a growing distaste, but they still felt loyal. He wrote that, well, many bad things are happening, and we see problems, but one thing that draws our attention, and that's appealing, is that the Law and Justice Party is overcoming the impossibilism, that it has agency. And this, I thought back to this during the Open Eyes Economic Summit. We discussed the index of Poland's credibility, reliability. Many things in our institutions don't work. And I spoke to representatives of the business community who were commenting on this index of public trust. They said that when the new government came to power, they gave it the benefit of the doubt. They believed that it would bring a better communication and solve problems. Now they have a growing sense of disappointment, disenchantment. And somebody said because they see a state which has agency, but which isn't efficient. It sounds better in Polish. We can organize a great news conference with PowerPoint stacks, or we can have wonderful conferences on the flood. But for the past year, we haven't been able to adopt a law that would enable wind farms or to deal with green transition, which is the challenge facing the Polish economy and Polish industry. So if we don't find a way of translating agency into efficiency, then we will continue to have a problem where it's politically easier to organize the semblances of agency, how we're overcoming obstacles. We're present on the border, we put on uniforms, security, we're looking after flood victims, but we can't address the procedural problems we're facing. And getting back to what Barbara said about the degeneration of democratic positions, and this unhealthy questioning of the mandate and authority of public institutions, I want to turn to you, and this conference, how this conference was organized. One of our inspirations, why are conferences be organized? Well, for two reasons. One, because you have to, and for the intellectual pleasure enjoyment of the organizers. This panel meets both these demands. In June, in Cultura Liberalna, Ben Stanley published an article about democratic hypocrisy. Having read that article, I thought, well, finally, somebody's opened up addressed this subject, and we, as the pro-democratic faction, can finally proceed to discussing not only what is on the verge of legality and democracy, but also take a look at how that affects changes the way the we perceive political processes. That was back in June. And if I recall, and nobody commented, it's not a subject that came up. So now in early December, practically, we're revisiting the subject. So Ben, what is democratic hypocrisy according to your research, and how did it affect voter choices, and is this something that will stay with us? Let me begin by saying that for a few years I've been doing research on democracy, and whenever I ask who agrees? Do you agree that democracy is the best political system? 85–90% respondents say that democracy, or a liberal democracy, is wonderful, is great. We appreciate it. We appreciate the institutions. But, well, first of all, we can notice that even though people say so when answering a survey, it's slightly different when it comes to voting. They vote for parties. Some of these parties are overtly anti-democratic or anti-liberal democratic. They want a democracy that would not be liberal, or even the way they rule, what they do when they come to power, shows that they do not value these political institutions. So the hypocrisy, democratic hypocrisy. So you could sum it up as a tendency to tolerate violations, abuses, infringements of norms and democratic standards when it's done by your preferred political party. When So it's a tendency we've observed in the last few years. We've been observing. So we're willing when we studied populism and related topics, populists were not in power, or if they were in power, they were a minority. They were in a coalition. Now we have a situation where we can see populists operating in practice. We can see, and what we're seeing is that people who criticize populism for the way it governs, the populists, the way they govern, they're more tolerant of such behavior when the government changes and when the political party they support is in power. Anyway, this belief that liberal democracy is the best system has led perhaps to a complacency as regards the resilience of liberal democracy as opposed to simple election-based ballot democracy. So some scholars, I'm not the only one who did research, so there was also a study done in the US which also demonstrated that there is that Biden voters in recent years, supporters of Biden, were more critical of Trump, of what Trump did, when Biden was in power during the Biden administration, and when they were asked whether they would tolerate certain things that cannot be reconciled with the spirit of liberal democracy, they were more prone to say yes. And I studied Poland over the last year. In October, actually, just before the elections last year, and in April of this year, I did a study which showed two things. First of all, that supporters of the present government are generally more democratic, more supportive of liberal democracy and its institutions. On the other hand, supporters of peace, of the Law and Justice Party, were less supportive of liberal democracy. But in the third study after the election, I saw clear differences between supporters of the present government. The supporters of the present government rather were less supportive of liberal democracy when it comes to, for instance, the independence of the judiciary, and whether the government should be able to censor the media if the media are critical of the government. In these two areas, the rule of law and the media freedom, I saw there was a clear change. As supporters of the present government are still more supportive, more pro-democratic than Law and Justice voters, but the difference is smaller. So the democratic hypocrisy is expressed in this difference. So when our guys are in power, we won't be that critical if they infringe. If they overstep the line, if they overstep liberal democracy.
I would like to add. I would add a few things to this conclusion about hypocrisy. I think that we are at a totally different place after 80 years of populism with an authoritarian bent, and nothing will ever be the same again, especially assessments of the government. So even today we will assess government using those cliches or calcs and like state effectiveness, meeting promises and so on. So I think that we are already on a certain track of how to assess governments and what is allowable and what is not. Another thing is that authoritarian type populists can win power using democratic slogans. And it is with these instruments that they obtain power, which they then use in a way that threatens democracy. And this research was done here in the US. And this has been confirmed. So how is the voter to differentiate between a populist that uses flowery language versus somebody who speaks democracy, but once they get into power, they treat the state and all its institutions instrumentally? Another thing, just to respond to a previous question, if politics is possible without populism, well, not anymore, I don't think. The question is, to what extent will it be harmful? Because it's better to have a populist in power who has this flowery language but has no temptation to undermine democracy than to have it the other way around. And what I'm worried about is what's happening in media and politics. Research that we did with UMK and the University of Wrocław during the first term of Law and Justice showed that a certain culture of political communication had broken down when it came to politicians' view of the role of the media, and that division is unequivocal. The parties that are in power today were complaining of the media, but yet they realized the role of the media was important in the democratic process, even if they wanted to influence the media agenda. Whereas the other side said why we should treat journalists and the media instrumentally. And I'm afraid of this. What Ben is saying shows a tribalism. If my guys are in power, let them do what they want, or, I'm turning a blind eye. And that is a consequence of those 8 years of authoritarian populism. Led to and made tribalism entrenched. And add to this, European scholars differentiate between post-communist populism, and my colleagues from UMK have written a nice text on this. We already know that there are certain traits, common traits to American, European, and post-communist populism. However, in Poland, the consequences of populism, as noted by Ben, go much further than in other institutionalized and established democracies. There are loads to unpack here. There's one thing I'd like to add, because I focused on attitudes toward voters, because that's what my research was about. But this is a tendency we see among political and media elites as well. It's hard to imagine for the government elite and the media supporting them would not have criticized initial attempts to make a purge at TVP if other sides had not done so. So there's a dose of hypocrisy, not just among ordinary people, but among the media and political elites as well. So let's, for a moment, assume nothing will ever be the same again. Populism is here to stay. You've also mentioned its negative consequences. Now, the research by Resadura and Świerakowski coined something called enlightened populism. So they see Tusk's first government with that, the flourishing of that idea, and then they traced how this policy of semi-populism also flourished in other EU countries. But Marek, getting back to you, is there something we can call enlightened populism? Can we live with that little dose of populism wherever it may be? When is it too much? When do things start getting dangerous for democracy? Are we there yet? I think that we are at a very dangerous turning point for democracy, because we're still living the hype of the US elections, but ahead of us are two electoral elections, the elections in Germany, and what happens there, what results populist parties attain there, that'll be important, but also how CDU will change if it gets into power, because it's changing internally. And the other elections, which are important for Poland, are the elections in Czechia? Because we did have a series of wins against populists. The very cynical Czech populists, Prime Minister Babiš, was on many levels a much more cynical authoritarian populist than anyone that we had here in Poland. And he's probably going to come back to power in Czechia after a cycle in which we had parliamentary and presidential elections that gave power to the liberals. And we have been through such a cycle, an even more terrifying one in Slovakia, where the populist and corrupt government was removed following mass protests incomparable to what we had in Poland, and they came back in style, and they came back replenished. If you listen to what Fico is saying about the media and what the political debate was like there, it's a truly terrifying lesson. And so I understand the question. The question is, can we allow a little bit of populism, or a sort of soft liberal with a bit of populism in the mix, to rule us, to protect us from the real populists? Well, actually, that's it. If you look at the last year, the one thing that the ruling coalition has in common is prevention, trying to prevent populists coming back to power. So let me say this. I'm currently preparing for an interview on the economy, and I have started going through layoffs in European industry, Volkswagen closing factories and others. We're facing a crisis of the German economic model, which is also a fundamental crisis for us, which we are not able to deal with from the standpoint of the society's poor. It's a very serious crisis. High energy prices, high prices of high quality food translate into very real problems for people living below the poverty line or earning minimum wage. So the question arises, this circus of enlightened populism, how long will it suffice if it doesn't solve these fundamental problems? So at the end of the day, you can kick this stone and you can make a very good narrative spin and stay in power as an enlightened populist, but at the end of the day, you need to solve the basic problems afflicting society, because those are the problems that will eventually hoist the unenlightened populists into power, the social problems that are just around the corner. So simple promises, easy solutions to hard problems. So somebody will come along and say, okay, so we're not able to bring about the energy transition within EU structures, within the framework of EU structures. We're not able to convince the EU to remodel its green transition model. So somebody else will come along who will say even more emphatically that they want to leave the EU and seal off the border. Poland will never formally exit the EU, but there are thousands of ways in which we can formally remain an EU member, but we can be outside of EU institutions and outside of the EU common market. And it's not even going to be the Europe of two velocities that we used to hear about. Magda, now about your experience and your research, we know that populism isn't just a thing here in Poland. And now that you've been following European policies, do you see that threat? And how can we step up to face the challenges? How can the new European Commission step up? So our research on EU integration shows that for populist actors, the European Union, paradoxically, is a very convenient arena that supports their narrative, and it does so unwittingly, but it also does little to deliberately counteract this. And maybe this awakening is happening in front of us, in front of our eyes. Why does that happen? Well, the EU is the ideal other that Ben spoke of, an ideal embodiment of the elite ruling over ordinary citizens, the real people, the real nation, quote unquote. Supranational institutions are a wonderful arena for populist leaders in which they stage the fight of the real people against these ideological bureaucrats or even these scheming politicians from neighboring countries that are plotting to wreak havoc. So we studied the subjective perceptions in Poland and in 11 other national contexts, perceptions of political actors taking part in the game to dominate European integration. The EU is becoming an arena that is very convenient for populists. Here are Hungarian colleagues, and this is one of my favorite quotes, once said that the Fidesz regime uses EU carrots and EU sticks. The more they beat our populists, the easier it is for them to sell their discourse. They're saying, look, we're being persecuted because we're actually doing the right thing for Hungary. And we know this. We are asking ourselves why that is. And it's not just about our part of Europe in this context, but quite a few of the populists getting into power are getting bolstered by the EU involuntarily. The EU, especially the European Commission, has very limited instruments they can use to react. There's simply no system and I think Ursula von der Leyen might as well sit there and respond to such attacks all the time, 24/7, and that probably wouldn't even be enough time, and she wouldn't get through to those who are I think of Brussels as a predator, and that is changing in front of our eyes, because European leaders, including von der Leyen, began to speak openly about this during the campaign prior to the EU Parliament elections, and they prepared a program. This was one of the flagship initiatives of the EC, which is now entering on a phase of legislation to prepare some kind of system to use that legislation. They call it the European Shield, or a European Shield to defend democracy, which includes financing. A third element, which is worth emphasizing, and these contexts, for many years, researchers, experts, activists, NGOs have been emphasizing this for many years. The EU finances these actors and finances them generously. And we see this changing. It's rare, however, that somebody does not get funds, structural funds, if they are actively standing up against European values. This has been a problem for many years, including in the Polish context. So this space of European integration has involuntarily become one of the preferred arenas for this game. The question is, can the EU become more of an agent, have more agency? Well, it depends on how much money they devote, how much money they spend, and how to what extent they'll be able to identify the bad actors. There's another nuance in this definition of the shield to defend democracy, or whatever it's called. There's special emphasis on external sources of disinformation. However, many researchers emphasize that we should be looking at internal agendas, internal agents of disinformation, because they are often equally or even more effective at spreading misinformation. It's clear that it's easier to put the blame elsewhere. However, we've been saying for many years, in fact, anybody who works on European integration, it'll never be the case that integration can protect anyone against anything. It's helpful, but it's worth noticing that sometimes it helps those who are attacking the EU or spreading visions that detract from the EU. So the populist thread in European narratives, and this is my last remark, we're seeing this quite clearly in research today. We're dealing with a new vision of European integration. This new vision, like Sergio Fabrini calls it, the Holy Alliance of nativism, populism, and nationalism. And those two components, plus some idea of how to integrate Europe today, it is producing a very attractive, appealing vision of European integration founded on the logic of having the cake and eating it too. It's quite internally conflicted. Sovereigntism, which presupposes that the main vessel that decides the fate of nations, that should be the nation state, and it's gaining popularity. We're seeing this in our research. It corresponds to what Ben was saying a little. The popularity of this vision is to some extent, to a large extent, due to the fact that pro-European forces are very reactive. They defend integration, saying, okay, we know there's problems in the EU, the policies are bad, energy prices going up, but you know, European integration is wonderful. And this position is no longer convincing to many, whereas the other side has a proactive vision. They're saying we're going to seize control and we're going to do the things that need to be done. So this shows that the language of populism often permeates down into places in which policies are rooted.
I wanted to add that the issue of sovereignty, and I'm glad you mentioned it, because the issue of sovereignty is crucial because it has to do with identity. Let me recall the Roderick triangle, which says that it's impossible to have globalization, a sovereign state, and a democracy. You can only have 2 out of 3. And I keep thinking of that when we look at the crisis of the model of globalization that we're currently seeing and looking for what's next. So the essence of Trump's policy decisions is how his attitude towards globalization. Very fascinating talks between Mexico and the U.S. Currently, which are riddled with paradox. Trump wants to protect the U.S. market from Mexican exports, while the leaders of Mexican export to the U.S. is General Motors and Ford. So this is a paradox wherein the question is, will we have move away from globalization, backsliding from globalization, or will we have a globalization which moves away from democracies? And that's we're only speaking about bilateral relations, which will provide a facade, facade of democracy. To refer to the getting back to the triangle, there's another triangle that I consider important at the moment. This is what I called it's the dilemma of post-liberalism, where the reforms that can be carried out, we can carry them out quickly, effectively, or you can carry them out lawfully. So the problem is that you can only have 2 out of 3, which leads to a problem, just like Donald Tusk recently noticed when he said that perhaps some militant democracy needs to be, or some militant democracy needs to be introduced to address this new type of impossibilism. And this is where they show agency. So the existence of this trilemma shows that we have a different situation now from an institutional standpoint, and also, and I think that this is important, in how to deal with populism, is that the norms are changing or have changed, not just in Poland, but also in many, many countries. The behavior fear, the rhetorics, and politics, which had a few years ago been considered inadmissible or extreme, is now becoming mainstream. Specific examples? Okay, actually somebody already mentioned this morning, somebody asked about the suspension of the right to asylum. Yeah, that's just an example. That is one example. There was a study, there's an excellent book by Vincenta Valentin, which was published recently on this subject. It's not that more people have extreme views at the moment. What has changed is that these views, these opinions, are now seen as admissible, legitimate, or at least as something which needs to be understood, which is legitimate. So even if right-wing parties, extreme right-wing parties, aren't in power, the more moderate parties aren't so afraid of saying extreme things. And from one point of view, this can be seen as positive. This can be seen as positive in terms of political pluralism, but then this puts the liberals in an uncomfortable, inconvenient position because you have greater pluralism, true, but pluralism also would have to include or embrace those who profess views that had until recently been seen as inadmissible in a liberal democracy. Let me just cut in. I know that Marta wanted to comment. Actually, all the panelists, I think, wanted to comment. I just wanted to say one thing that came out in our research. We looked at the narratives on the future of Europe, and like many other things, they are polarized. So what is the byproduct of this polarization? Regardless of the increasingly radical narrative, and so what we're seeing is the institutional collapse of the position of Parliament as the main forum for discussion. We have a forum. I can't show a project. I can't show you the findings, but we're looking at over a dozen nations. That doesn't just happen in countries where populists are in power, but we're doing a study based on the quality, looking at the quality of debate, of the construction of the discursive other, linguistic violence and behavioral violence in Parliament, and how this erodes Parliament. But can we have a democracy without a Parliament? So the question that recurs when the process begins, how quickly it transforms, it trickles down to institutions and weakens them, and leaves us in a situation where we're left wondering what to do with democracies when the main institution, the main bulwark of democracy no longer performs this function, or there's a void which is filled with a vision, a dream of a strong man who will come and put it all together. So Marek or Barbara? Yeah, two other important things. As we've said already, populists don't have to be in power. It's enough for them to have 30 or 25% of the vote, as is the case in our Western neighbor, where it's totally devastating. And such power representing certain interests already has an impact on what's happening. Second, Ben noticed something really crucial on the mixing of orders. The permeation, I call this a hybridization of communications systems, where you can use propaganda along with positive normal communication side by side. So there is this disrupted order, and there's the issue of a real leadership, real political leadership, which is missing today, of which we have a deficit today. And to counteract populism, you need a true political leader. So who would, I don't know if it's possible at all, who would use these, what American political scientists, restraint, moderation, the principle of restraint. So something's not written down explicitly, but it's just not done. So I think there is no restraint in politicians. They'd have, even if so, if something is not explicitly prohibited, it's allowed. So again, we're talking about meta levels, how liberal democracy will deal with these processes, because now all the odds are in the favor of populists. A fear of culture change, which happened in the States, a fear of the other immigrants, literally, who have materialized, manifest. This will be a European problem due to climate change, war, armed conflict, and also the pace of life, the aspirations, which are dreams, which are becoming impossible to achieve. And I'm also thinking about political processes that are underway. The American perspective, I usually extrapolate with caution, but this did inspire me. So there are interesting studies on polarization in the US, constructive and not effective polarization. It all boils down to the fact that we need a center, a healthy political center. But how is this center to emerge if it has to use the vocabulary, use the language? So for a center to emerge, the extremes would have to stop fighting, extreme left and extreme right, and this is not likely. So this is a huge challenge for liberal democracy and for political leaders. So we need a quality political leader. I just wanted to get back to one thing Ben said. Ben mentioned migration. 2 days ago, we had a hearing of public benefit organizations and NGOs with the Minister for Civil Society, attended by Deputy Minister Duszczyk, the author of the migration strategy. And it was sad. It was a sad event because of what the organizations said. But getting back to this question about enlightened populism, the question we have to ask ourselves is how far you can go if for the present government is responding to a social demand, is getting back to the need for security, and it's designing a migration policy in such a way that it's based on security. It addresses security concerns that will also shape the language of the government. I did an interview where the deputy prime minister said that there were people running around along the border with spears, and Minister Duszczyk said that there was extreme human rights demands being made. I don't think he said that verbatim, but something to the effect that extreme human rights demand. So a language that appeases, that's intended to allay these concerns, it begins to affect us. So the mask you put on to protect you from bad populism begins to becomes like part of your face. So, but what do you do how do you address human concerns? These concerns are real. There's a sense of identity where, for example, we ought to start discussing what it means to be Polish. How does the national community look? And there's two things that I also referred to in my questions, hinted at in my questions, the role of media and polarization. But before we move on, I wanted to ask our audience whether they have any comments or questions at this time, because now would be a good time to ask these questions. I see two persons who want to. Magda Krzyżanowska-Mierzewska, this is very interesting what you're saying, but I think it would be even more interesting if you would care to translate that into specific events in Poland, or refer to specific events in Poland, provide examples, or refer to the challenges we spoke about before lunch, related to restoring the rule of law. Eva Siedlecka, let me just comment on what Magda said. Let me just follow up to make it more concrete. I feel that, actually no, I don't, I believe that populists are once again in power, and So how should the government address concerns and actual sense of threat that it had whipped up? Because talking of spears and also building up a narrative, an entire narrative about murdering a Polish soldier and handcuffing our soldiers being handcuffed because they were attacked by a horde of migrants who had crossed the border. This turned out to be not true, but it was a narrative put in place to adopt an act that made troops exempt from use of weapons, from any charges related to use of weapons. I'm not a political scientist. Populists are in power. I think you were talking about threats to democracy. I feel that democracy is already threatened by politicians for whom populism is an instrument to win power. Power is won via using populism today. And whereas previously we had a democracy that was the majority rule, which was limited by human rights, now we have democracy as majority rule, full stop. I think that human rights, there's no room left for human rights. And as you said just now, Minister Duszczyk, the Deputy Minister of the Interior, spoke about extreme human rights demands or opinions. I feel that shortly these human rights extremism will be human rights terrorism, just as they speak of eco-terrorism. It's all thrown into the same baskets, or actually that part of society that has ethical and moral demands are placed beyond the pale. They're treated as extremists, so that interests and emotions can be achieved at the expense of values. Good afternoon, Agnieszka Boremska. I have a question. This part of this panel is a little sad, but my question is there a chance at an age of populism, can we build up a civil society that would be aware, that would be, and second question, if we are able to create a civil society, will the job of this civil society be to fight populism? And if so, if not, then who will need to counter this populism? Ewa Hołuszko, I have a topic that wasn't addressed yet. At the moment, on the one hand, you have human rights, which are the rights of every individual, and then there is security, the threat to security, which restricts human rights. So how? I mean, you could say that populists are in power because they restrict human rights, but the populists in power can say that the situation demands that we impose restrictions. So how do you reconcile these two things? I'm not talking about 2015. I had fought for human rights. I was in the parliamentary committee working on the Act on Migrants, which was suspended by the Law and Justice, but I was defeated by populists who speak about human rights. We're saying to the effect that everybody can enter because we have human rights, and I understand this, but at the moment, so where do you draw the line? It's not both sides are afraid to ask, to say where you draw the line.
So this is a big discussion, and I would also like to contribute something, but I don't know if you'll agree. Well, it's hard for me to disagree, so maybe I'll check with the panel. Would anybody like to respond to any of those questions and comments? Because we have several groups of problems. How to fight populism, we're ruled by populists, what to do about it, and the dichotomies that keep reappearing. And they are related not only to the legal dilemma of how to balance security versus human rights, but also how to take care of those emotions, the fears, and so on. So before I respond, let me point to one thing that was said, but maybe it didn't really have resonance. The problem with actors who use populist communication structures, but underneath the populist language, they have a certain agenda. Like you said, Ben, certain forms, an illiberal agenda. This practice, and we see this clearly in discursive research, they appropriate certain concepts. They take concepts from consensual social language, they take those away from the mainstream, they fill them with their own content, and they throw them back to people with a radicalized meaning. Scholars of European integration, which is where I feel most competent, have shown, and they call it narrative jujitsu. That's a very evocative term. I learned about it from Kaiser McMahon's text. Jiu-jitsu is a Japanese martial art whose main feature is to use the force, the power, the strength of the other person to our own advantage. So we need to remember this narrative jiu-jitsu in the context of who is a populist and why. What is their agenda? So this narrative jiu-jitsu, the way it works is that those anti-European narratives took advantage of the opponent's strength to build an even stronger narrative against the European project. Now, it's mostly they took away the concepts and reinterpreted them. So if we take this to Poland, we can imagine that part of the game that we're watching, which shocks not just countries but everyone, it's a game, a competition to take back concepts that had been appropriated and misappropriated. Now, is it jiu-jitsu to take them back and use the reverse force and to restore those concepts to their original meaning? There's always the question of what, like, take the notion of security or community, a community that is threatened, that is under attack. If we take that notion back, can we come back to what was there at the beginning? So a consensus. Or will the concept always be appropriated and changed, and the jiu-jitsu will just go on and amplify? So we have to keep in mind that the whole game is also about fundamental notions that define who we are here and now, and what we want to defend against, who we want to defend against, and in what context. But it does have a whole variety of meanings in our public arena, and that these notions are essentially what is at stake. I would like to respond to several issues that were mentioned. Eva Siedlecka said values. That's very important, and this is a piece of the puzzle that's missing in the whole populist environment. This is an argument that keeps getting thrown around. The migration issue, and here I second the statement that if we ignore people's fears, populists will get into power who won't have a doubt as to whether the takeover of public media was legal, licit, or not. They simply won't care. They'll just put people in prison without heed of whether it's legal or not. So not looking after those fears will lead to authoritarianism. So in 2.5 years, if we get a different government, we won't have these dilemmas and discussions anymore. So now for those security-related issues, I think that today there is it's hard to articulate what the role of government is. The government doesn't even know what to do about it itself, regardless of political option. So the first issue for the government is to defend Poland's borders. That is why we have liberal democracy with its laws, institutions, and written and unwritten laws, and human rights. The law is there to be followed, to be obeyed. So I think this is walking a thin red line. Just because somebody is afraid, we cannot take steps that are reminiscent, and though I'm trying not to put everyone in the same basket, that are reminiscent of populist moves. However, a lady said something important. It's about the quality of communication. So treating voters, empowering voters. Voters supporting the coalition want to be taken seriously rather than treated as objects instrumentally. So I think it's an issue of quality communication. There's no dialogue with NGOs dealing with migration. There's no openness to this. And finally, you asked about civil society. All hands on board when it comes to fighting populism. The media have a huge role to play here. But you touched the core. We have certain models, certain tried and tested solutions. We need depolarization in the sense of effective depolarization. Polarization sparked by emotions, by fearing strangers. So we need to go one level down. In the case of Poland, it's very important to have civil society, micro-communities. So in essence, if we are, say, in a housing estate, in a municipality, in a small town, at some point when we're facing our problems, it doesn't matter who you're voting for, whether it's Law and Justice or somebody else, because we have a shared goal. So moving certain activities down one level, we're supporting depolarization. We won't do this in 2 to 5 years. It's a long process. However, maintaining a quality civil society, relations between people, the decision makers, and civil communities, it is an important component in dealing with the destruction wrought by authoritarian populism. In point 2, you mentioned this civil hearing on migration. It's not just a communication, it's about how the process was managed. This was a hearing about a document that had been approved in a situation where people didn't know what would happen with their proposals. So a political decision was made, and now we're going to hear you out. One final word, and this is going to be cynical, very pragmatically. For a politician, it's more important that some percentage of the population is afraid and they prefer to make the decision instead of consulting society, because politicians will think, okay, NGOs will complain, but the fact is that an X amount of people, percentage of society, are afraid. They need a solution. They need a clear message. Okay, but we're getting to the core issue here. We're talking about suspending the right to asylum, which is not feasible. But then we have a bunch of processes that lead nowhere. So the final question is, can we put the genie back in the bottle once it's out? It's not just out a little. It's it's driving it's in the driver's seat. So Ben, Mark, do you want to respond? We have 5 minutes to discuss the role of the media. So I think what we have to do is we're going to wrap things up with your observations, and we'll end it there, and then we'll steal a bit of time from the next panel. Yes, I do have 5 minutes, but I have 20 minutes. Why did I think I only have 5? Well, okay, then all's good. Okay, so we'll have time for questions. Okay, let's rewind that. Okay, responses to what Gosia said. I see one lady raising her hand, and Krzysztof. One thing regarding the statement that there's so much pessimism in the room. Well, things are tough, but there are so many things we can do. that we need to do, that NGOs can do, why are they to have a more complicated accountancy than business? Why is that happening? We have a minister for civil society, so we need to work with her to change those regulations. Second, local communities. That is the level where we need to create infrastructure for those NGOs, where they can function. A mailing address, a conference room. That is where the work is to be done, in the small towns, because that's also where the big fears are. There's another issue for all of us. The awful things the Polish right has done to itself. The Polish right arose out of a dream about building an effective, efficient state back in the 90s. They simply wanted to build a better country. And what they've done to themselves, they have become servants to particular politicians, their mouthpieces. They have become part of the game. They became politicians. So my impression is that the liberal side should watch out and to assertively say to itself, to admit some maybe not brutal but honest things. So the hearing that Minister Duszczyk, where Minister Duszczyk heard several things once again, he hears them every once in a while. It's necessary to keep public debate going, thus segueing into media. When I heard the question as to whether it's possible to have a functional civil society in Poland, it occurred to me that, in fact, we do have a pluralist civil society, or rather two parallel societies, civil societies that don't talk to each other, or that talk to each other less and less. And that is the key issue. So I agree with Basia that it's a problem that can be solved on the lowermost level by focusing on common problems. However, I am more pessimistic when it comes to the approach of political elites, because I'm not seeing any political willpower, or I don't know if politicians have any interest in changing the state of affairs, because we have a society which, when politics are concerned on basic political issues, this society is not that polarized on many questions, but they are polarized in the sense that they hate each other, and that is very beneficial to politicians. So different political parties exist. Some of them have single-digit support, and they can join the ruling coalition, because it should be noted that Law and Justice in recent times had 2 percentage points less than back in 2015. On the other hand, none of the Polish political parties was able to achieve voter mobilization on a par with Law and Justice. They need polarization to rule, to be in power, to get into power. So from the social standpoint, I'm more optimistic, but politically speaking, I'm not. We need to repeat what was said over the past 20 years consistently. A new generation of politicians has to come around, who are not attached to those feuds. So what are your predictions for the presidential campaign? Will it be polarized or very polarized? Extremely polarized? So what if this was a duel between Sikorski and Czarnek? Then that would be polarizing. Now, it's like medium rare. However, the campaign itself might be less polarized than expected. However, the problem is still that these elections, if we are looking at Trzaskowski to win, so the ruling coalition will expect more. We'll think that more is realistic. So now we have the presidential veto. Some things will be more easily obtainable. And then the problems which the government experienced in recent months will disappear. There are certain expectations from supporters. On the other hand, not all the problems can be solved in a straightforward way, so that could create difficulties. So I don't think the campaign will be that polarized. However, the post-electoral dynamics might be polarized. And how do we manage so many conflicting interests inside such a big coalition? I see 3 more people raising hands, 5, and we still have the media to talk about.
So, yes, please, the lady, and if these are quick questions, we can maybe take them all. Good afternoon. My name is Kazimierz Machcewicz, and I want to comment on 2 things, on things that were addressed by yourselves in this most interesting debate. First of all, there's the answer to the question, for what reason in our times, why is it that we have this epidemic of populism? What has changed? What has changed so much that we've lived to see such an age? And consequently, again, this isn't my answer, but maybe a suggestion. How do you see the role of social media in all this? And second, this is also something you've addressed, is the appropriation, the terrifying appropriation of concepts, the hijacking of concepts that have been used, like concepts like rule of law, constitution, act of law, how these concepts have been hijacked, appropriated by people we see on TV, on people we see in Parliament, who are yelling, screaming about how our side is in breach of the Constitution, in breach of the law. So I'm personally terrified and appalled when I read how supporters of President Duda, after everything that's happened, after the elections, that there are 47% of the population supports the president. And I think that we're not putting enough effort to fight something that Polish poet Julian Tuwim wrote about, how our words shouldn't be deviously distorted, and they should be restored their unity. Let the law mean the law and justice mean justice for all time. I see no attempts to oppose this attempt to hijack and appropriate. Thank you very much, and thank you for also mentioning social media. We will be getting back to that. We had 2 ladies in the back. Yes, the professor and the gentleman. Karolina Hajnowska, good afternoon. I have a question on a topic that hasn't been addressed yet, as namely the role of foreign actors and populism. So, for instance, society and as citizens, how we can oppose, for instance, Russia, Russia troll farms, Russian bot farms, Russia which supports populist parties, and there are also many Russian agents around, agents of influence. How would you refer to that? How would you and now Anna Tatar from the Never Again Association. For years, we've been trying to fight xenophobia and racism. We've been following a public debate. In the autumn of last year, we published a report on hate speech as used by politicians, and the observations were shattering. Everybody was using migrants as a bugbear. My question is naive and might have to do with an alternative reality, but my question is, how would you see a prime minister or how can you change, how could they change the message instead of saying that the right to asylum will no longer apply in Poland? Do you have any examples of a head of state or government leader who managed to change the message so that it's not naive, it's not polarizing, but somebody who can honestly, candidly present the facts instead of exploiting the reality in a cynical fashion? We have the lady here, Krystyna Skarżyńska. I'm a sociologist. I listened in on two debates. Two were very different. This one was more animated, but I have to say that there's one thing I find pessimistic, and I saw this here. I see two sides, just as it's like communism. It's like communist times. You have civil society and you have politicians, and never the twain shall meet. None of them empowers the other. I've seen this over the past 4 hours, and if this is the case, then it will be difficult to create a society that will be democratic. Appropriation, hijacking, or changing the meaning of definitions. This is something that happens everywhere, and it's a necessary. Education. Everybody talks about education at meetings like this, but for 30 years, the European Union was seen as a piggy bank and not as common values. People said that there were no common values, no common history, and nothing's being done to address this. And now for the question, why is it that there's in this discussion among lawyers and in your debate, why is there no mention made about liberal democracy? Because liberal democracy, appearances to the contrary, is a universalist democracy, and then you don't have others or strangers. Everybody needs to be treated as human beings. I see no readiness to recognize the others than my group. So I see no, and politicians, as you, you only see politicians as Machiavellian manipulators and who are only interested in power. There are some politicians who want something else than power, not just power. Right, now we have 5 minutes left, definitely. And we won't have any, so we'll need to gallop through these questions, and I'll ask you for a word or an attempt at summary, as you see it, of this discussion. Yes, Marek Teichma, on social media, because I fully agree, of course, that social media is the dominating subject issue. In Poland, notice how active Polish politicians are on social media. Like what Twitter does to people, it's not just the readers, but it's also a fix for those who tweet, those who live off likes. And I find it terrifying that Polish politicians run their own Twitter accounts. They like each other, and instead of reading a good book or just resting. They just sit and tweet. But populists didn't arise with social media. The mass media that we created in the first decade of the 21st century. So we can blame the mass media also for what happened in Polish politics. And I say this as someone who is and was part of the media landscape, inviting the same politicians only so they would fight on TV or quarrel on TV. I remember news programs where I said that the Chiron shouldn't say important, but you called politicians, asking them. They didn't even want to know what we would be talking about. So the mass media are to blame, the 24-hour news cycle, and this is also because it's a lot easier, a lot simpler, a lot quicker, and that's because the media are incompetent, and this is a growing incompetence. It's not that social media is the enemy. What is the problem is that Polish media and Polish journalists are taking the easy way out. It's shortcuts. And to end on an optimistic note, it's not just countries like the UK or the US, but in countries closer to home, Sweden, Norway, even Slovakia. You have media which are quality media, which establish a relationship. Denmi, a Slovak newspaper, is a subscription only, and they have very good journalism. The same is true for Sweden. And Germany and the Netherlands are different here, but I truly believe that just as we will be building civil society, so we will also build up quality media. But it's not the case that social media is to blame. It's also journalists who became fans of this game, who became onlookers. I have a lot of notes, but I have a brief, concise reply. Yeah, we know that populism is the product of is due to certain economic issues, the U.S. And in the West, and cultural matters. People felt fear, concern, and the role of the media. For years, we've been discussing, debating studies which have shown that the media has contributed to the rise in populism because the language of populism is very attractive to the media, and the media are commercial, so they need to make a profit, so they're looking at clickbait. And what's also positive is that constructive journalism, quality journalism, is being is a concept. I would even go a little bit further with the optimism. I think that today we have a chance opening for traditional media, for radio. People trust the radio, and I think there is a chance for institutional media, traditional media, in an age of fake news and disinformation, to take back the initiative, to guarantee that the sources that information has been fact-checked. So how could a prime minister change the message? I don't have any examples. It's not simple. Politicians like to speak divisively or to polarize, but I think you could respond to this by saying, look, for now, we need to change our migration policy. We need to change the way we give international protection. And politicians should speak about the need to incorporate migration policy. We need migrants economically. So politicians will say we'll need so many people over the next few years. There are conditions, there are countries which can be benchmarks, like Australia, which has clear guidelines who can enter. And so that's the way I see it. You could just put it normally without referring to like spears, or without speaking of parasites, diseases, and without dehumanizing people. And finally, Professor Skarżyńska spoke about politics. I appreciate that because there is a positive note. I think that we need to demystify the word politician. It's not something that should repel us, revolt us. We shouldn't say that politicians lie and they're nasty because this will discourage people. This will demotivate people. In the US, there's an interesting concept of disenchantment, so okay, if we can't, there's nothing we can do about it. Whatever I do, they do whatever they like. It's them, so I will stop voting. And this is where more efficient, effective populists profit on that. So this discouragement with this disenchantment, again, of course, it's also aggravated by the resources of the opponents of the West, the technology and the resources that's being put into this by Russia. Of course, Russia geographically is the main sponsor, the main actor here, but also like the latest recent elections in the first round in Romania, there's also a Chinese influence. So authoritarians are adversaries, oppose the democratic way of life. No matter how critical of that way of life we might be, they want us to stop being democracies. Macron said that in his second Sorbonne address, where he quotes Paul Valéry, saying that civilizations are mortal and Europe, as we know it, can die before our very eyes if we surrender, if we give in to those who want to take away this democratic quality, which is at the heart of the process. And as I said, this requires a well thought out strategy, a well financed policy, which would be based on education, which is something mentioned here once. And education can, in the long run, keep us safe from certain things. There's no ready fix. There's no way of defending ourselves against a better way than of opposing post-truth than teaching the younger generation. Ben mentioned the generation change. There's the young people and young voters, their role, this generation shift, and I think this pessimism is warranted because the younger generation isn't really, we're not seeing any clear trend. And so that they're more resistant, more to this post-truth, despite their experience in social media. In our study, we asked ourselves, okay, we have politicians in Poland, so how many reforms, do you know what the study showed? Generally, statistically, most politicians in debates on these issues have nothing to propose. So what is the role of civil society? What is the role of the media? There is to ask the question again, if you don't want this or that, then what do you want? So to bring the discussion down to the essentials. Somebody has to step up. It won't be politicians. Somebody has to ask the question, so what is it? What is your position all about? What is Ben, getting back to this appropriation of concepts, this hijacking of concepts, the present opposition is now beginning to talk about the importance of the Constitution. I think that it's, just as I said before, I think that what's changing, things change when the liberal institutions and democratic institutions turn out to be necessary. It's good to have public media that aren't just a propaganda mouthpiece. It's and you need to have a judiciary, so you see the advantages of a judiciary that's impartial and unbiased. So I think that partly it is possible. I mean, supporters for law and justice supporters. So their experience of being the opposition will show them why these institutions are important and why these standards need to be abided by, respected. And in closing, to comment on the question about foreign influence, I think we often focus on the negative influence from like Russia or other actors, other countries that are authoritarian or populist. But what's no less important is for our friends, for our friends to be more strict, more harsher in criticizing what we do. I think when I think of when after the coalition won the election last year, there was a sense of euphoria for some time. So that's how Polish people were managed to defeat the populists. This was important in the media. This was important for politicians in the West because it shows that it's possible. Since then, however, we've seen a tendency to treat the Polish government as to give them leniently, to treat them like leniently, and and you can even get a Chatham House award like Donald Tusk did. So for being a rational partner, and so in kid gloves. And if we want to reform liberal democracy and show that populism isn't the way to achieve this, we need to listen not just to our opponents, our adversaries, but also hear what our friends have to say. And if the European Union and EU institutions, if they were more demanding, more critical of the present government, then it'll be more difficult for the populists to claim that the European Union favors one side, is partisan, is biased, and so yeah, time will tell. Ladies and gentlemen, thank you all very much for your patience. We've dragged it out a little bit, but thanks for your participation and your presence. And just one more favor, let's thank our wonderful panelists. This is the end of the panel, but not the end of our conference. Join us in 10 minutes. We'll be talking about how populists abuse or disavow or
Przerwa kawowa dobiegła.
So our coffee.
Has been just over. Some accepted the news, some didn't. Anyway, I think we're gonna start. Okay. Good afternoon, everyone. Ten panel będzie odbywał się.
So this panel is going to be in English, and if anybody needs interpretation into Polish, you should pick up a headset.
Will be held in English. We're going to discuss the last topic of today's conference. Yeah. Hi everyone. Barbara Grabowska-Moros, CEU Democracy Institute in Budapest. We will be able to discuss the last topic of today's conference, and that is we are going to discuss how the populists affect and change the human rights systems in different jurisdictions. Małgorzata Szuleka, who was the head of the previous panel, she did an amazing job with collecting this panel as well. We will be able to discuss different human rights issues related to illiberalism and related to the populism, together with Renata Uitz, who is a professor of law and government at Royal Holloway University of London. She is also a senior research fellow at CUDI in Budapest, and her research deals with public law, with comparative law, also in the context of transition to and from constitutional democracy. Also, Edith Zgudz-Przybylska is today with us. She's an assistant professor at the Institute of Philosophy and Sociology at the Polish Academy of Science. In her past life, she was a journalist in Hungary, so she has really brought not just theoretical but also practical knowledge about freedom of media. And last but not least, Alan Zisse, who is a senior research fellow in public law at University of Glasgow, whose research deals with public law, international law, political theory and practice of the ECHR in particular. So today we already were able to discuss the Polish developments in the context of transition to the rule of law. We were able to discuss the populism in the last panel from various perspectives. And I think now we would dig into something very concrete, but something which affects not just Polish case study and Polish jurisdiction, but basically you could find interesting examples everywhere. I forgot to mention there are two news. One good news is that we're going to finish at 5, and bad news is we are going to finish at 5. So we have to adjust the Q&A session depending how long it will take us to discuss the topic. Last year, when we discussed a similar topic exactly in the same place, I remember we were discussing, for instance, the way how the Polish Constitutional Tribunal were used or abused by the Polish government to get protection against international courts rulings, which dealt with judicial independence, for instance. Another sign of how the system could be abused is the idea also introduced in Poland, which is cyclical assemblies. So idea basically to limit protests against government, and which was interpreted again by the Polish tribunal as something which actually expands freedom of assembly. So I think it was another example when the system of human rights protection could be abused. But my first question to all the panelists would be, how can you say that the human rights system was abused by illiberals? And what are the methods you could diagnose as those that might lead to making the human rights system losing its main purpose, meaning protecting freedoms and rights? Maybe let's start with Renata.
Thank you very much, Barbara, and thank you very much for the invitation. So let me start with saying that the system was captured gradually and through trial and error. The amazing part is that this was not the prime objective of the illiberal and populist actors. They almost stumbled up on it. And when they first came up against what seemed like expected obstacles, they found it extremely easy to get away with it, because there was very little resistance, and also there was extremely little systemic response, both from Strasbourg and also from the European Union. So if we start from the European Union, just keep in mind that what Hungary triggered was the rule of law crisis. But the rule of law crisis was not the big crisis of the European Union at the time. The European Union also had Brexit, it had a migration crisis, it had a financial crisis, and then it had COVID. So to say the least, the little bit of conundrum in East Central Europe was one of the smaller problems. And because of the lukewarm response, the trepidation of the Commission, and then the dialogic processes they chose, they essentially turned this illiberal playbook into a real set of political opportunities. Now, when you go to the human rights regime, I would like to say that essentially the likes of Hungary, and then Poland joined later, had both unexpected assistance and unexpected allies on the way. And we can start with the Western governments that by that time were really fed up with the European Court of Human Rights. They were fed up with having to let terrorists out of jail. They were fed up with having to give prisoners voting rights. So by the time Orban and PiS arrive on the scene, we have the Brighton process in full swing, and this is a process which is led by Western governments in the Council of Europe. You also have joining the bandwagon from the US, American academics who are starting to attack the authority of the human rights regime as such. They are going after its liberal premises, especially against its extreme individuality and its failures to provide goods which we associate with social welfare rights. And then, of course, we have the conservative legal movement that is alleging the proliferation of unnatural rights. We have litigation tactics and funding in the US. And then we have the entire French wave of going against human rightsism in Europe, supported by the European Center for Law and Justice and similar litigation. So it's crucial to see that when it, on a systemic level, when this lands in Europe, there is actually plenty of Western support from the heartland of the human rights regime that provides a very fertile ground for some of these arguments. So I think we will come back to talking about how this misappropriation or what I call recalibration of human rights is happening. But I wanted to really open with saying that while we might be the heartland of an illiberal human rights recalibration, there was plenty of support from the beginning, and we need to see how that it was so easy. In part because the seeds were planted and the resources were available for these arguments. So add to this the recent electoral successes of right-wing populist government, and I'm not only talking about Trump's victory, I'm talking about Austria, I'm talking about the Romanian presidential elections, and you see the electoral appeal of the type of rhetoric that is against constitutional democracy, against counter-majoritarian guarantees, and definitely against liberal human rights as we know it. So this is setting the scene and passing on to the others.
And I think it was already mentioned in the previous panel, exactly changing of terms used in the human rights narrative. And let's move now to Strasbourg, and let's take a look how the recalibration looked from that perspective. Alan?
Yeah, sure. So I think when we look specifically at the Strasbourg system, I think the piece of good news is that the Strasbourg court itself has not yet been captured by populist forces. So the only way in which I see a potential threat to the independence of that court is only if state parties start appointing judges that are more lenient and more inclined towards authoritarian populism. So that's good news. But on the other hand, the Strasbourg system is a system that allows or places a lot of emphasis on the primacy of state parties. And you can see that at 3 different levels of the system. You can see that in the sense that individuals, if you want to make it to the Strasbourg court, they need to exhaust domestic remedies. So states have a primacy there in interpreting the convention. And then you have the interpretive stage, at the merit stage, when individuals have actually made it and have their cases admitted at the court. And here you can see also a lot of discretion and primacy given to the argument given by states, especially when it is relying on democracy. And then you have the third stage, which is the stage of remedies. And here again, states benefit from a lot of discretion in exactly choosing how they're going to implement an adverse judgment. Okay, so it's a system that I think relies very much on the contribution of states, but also on the good faith contribution of these states. And I see opportunities for abuse at these 3 different levels. So in my research, I look specifically at the interpretive stage. And so how can we see that rogue states basically are attempting to abuse the system? Take the example of the mode of appointment of judges in Poland through the National Council of the Judiciary. If you look at arguments that were presented by the government of Poland in attempting to justify restriction of human rights, they would say, well, there's no universal mode of electing judges in Europe. There's no European consensus on how judges should be appointed. So the reliance of this language of European consensus, for example, is an instance where they're trying to use the very concepts and methods that the court itself uses to adjudicate these issues. So what I'm trying to say here is that given the space that there is for rogue states to actually claim that they are restricting these rights based on grounds that the convention, the European Convention itself permits. So states will be able to claim, for example, that while they are dismantling their judicial system, they are saying that they are actually protecting the impartiality of the judiciary, for example. So maybe that's just a couple of examples where I think that these governments are playing from within the language and the catalog of references and methods that the court itself uses. And I think I would resist saying that there is abuse. I think it's more exploiting the discretion that the system leaves them and that the system depends on.
So maybe now let's move to Edith with the same question, but maybe let's try to zoom in to Hungary, and this is as a case study, as Alan was discussing, exhaustion of domestic remedies, and Hungarian example is super interesting here, since the European Court of Human Rights still perceives the Hungarian Constitutional Court constitutional complaint before the domestic court as an effective remedy, and this is the standard that Hungarian litigants have to exhaust in order to go to Strasbourg. As a comparison, in the Polish cases, I think the court tried to avoid answering this question. So it's somewhere in between. in the couple of cases when there are no complaint exhausted at domestic level, and there was a ruling issued by the court saying yes, there's a violation. But still, it seems to me the Hungarian case study is way more difficult than the Polish case, especially, yeah, it's a function of time, right? So the liberal system had way more time to exploit the human rights system. What's your observations on that, Edith?
Thank you so much. I'm also very happy to be here. And given that I'm not a constitutional scholar, but a sociologist and a political scientist, I would love to approach this a little bit from a different perspective, from how the social and political polarization became not a byproduct of the activity of a populist Hungarian government, but an instrument to undermine the human rights and the human rights system. Very briefly, the playbook that the Hungarian government has been following has been employing two approaches. One of them was the vertical and the horizontal polarization. And this is very important because what we eventually saw happening in Hungary is that with the vertical polarization, the government for 14 years has been telling the story that our sovereignty and our national sovereignty has been undermined by the European Union, by the EU Court of Justice, by the European Commission, you name it, but also the West in general, and also US Democrats and many different type of enemies from top down. So this is kind of the vertical side of things, that we are always being threatened by someone up there. It's very abstract. But the government has been also very successful with the horizontal polarization. And this is crucial here when it comes to the human rights, because what Fidesz has been doing is that they have been naming, shaming, and blaming different kind of minority groups, sexual minority groups, homeless people, disabled people, very different kind of category of society, as so to say, different kind of enemies of the true people. So if we are sticking to the form of populism. And I think gender is very important here because it has been like functioning as a symbolic glue, also connecting the Hungarian government with different kind of other organizations on the international stage in the United States and many other countries. And they have been constantly referring to the will of the majority of the society to keep saying that rule of law, human rights kind of structures and ideas are undermining the will of the majority of the people. These are obstacles to get things done for the people. It's a very typical populist approach. And I think Hungary is a laboratory in this regard. So, but the important thing is that it wasn't just naming, shaming, and blaming, like talking the talk. The government was walking the walk in a sense that they have been doing changes on 3 different domains. One of them was the political discourse that I was starting with. We have been witnessing tremendous amount of defamation campaign, propaganda, pro-Russian propaganda when it comes to these minority groups and institutions. Disinformation, which is importantly not pushed by fringe media organizations, by the media, the mainstream media, which has been captured by the government. So here comes the institutional side of the problem, that the key venue of anti-LGBTQ, anti-human rights, pro-Russian disinformation is the mainstream government-controlled media. So this is the discursive level. The institutional level is even more problematic in a sense that there has been a lot of laws that have been made with the constitutional majority in the last 14 years to undermine the sexual minority community or the migrants. We also, the latest version of this approach was a bogus so-called National Sovereignty Protection Office, which is technically able to harass and investigate and hunt down anybody in the country who is being financed somehow by foreign actors. We can, go into details later on. And the third level is the policy measure level, because it's not just about the discourse and so to say, the institutional kind of change of things. But if you look at the policy measures of the government, this government is gradually excluding different kind of minority groups within the society from social benefits, for instance. And to give you a couple of examples, when it comes to social benefits and childcare kind of tax deduction benefits, the government is mainly focusing on married couples within the country. So if you're a single parent or if you're belonging to an LGBTQ community, you're technically excluded from this kind of benefits. So it's very much exclusionary and very much uneven. And so if you take this as a package, you can get the idea how eventually this kind of toxic polarization effectively works in the country, and how disturbing it is in a sense that it's a very dangerous zero-sum game, because it's not only threatening, you know, the quality of governance and the quality of democracy, but also undermines social trust within the society, and it's weakening, not like weakening pluralism, it's technically demolishing pluralism and leaves a very small kind of space for any kind of meaningful debate within the country. So I think what's the most important problem here is that when it comes to the domestic actors, what democratic forces would need to figure out how to mitigate this problem if they cannot fully eliminate it, because I don't think we can fully eliminate it. It's going to stay. Yeah, happy to discuss it further in the second round, how to.
So maybe let's move on with something which you mentioned in your presentation, meaning the anti-LGBTI law adopted by Hungary. And since the question is not only about, you know, past, how the populists will manage to capture the system, but also to look forward, how to deal with that, how to look for potential resilience or resistance against this capture. So let's take a look at this case. 2 weeks ago, there was a hearing in Luxembourg dealing exactly with this case. There was a commission infringement action against Hungary on this anti-LGBT law. And there were like 12 or 15 other member state governments who joined the case in favor of the commission's arguments. So I'm just thinking, you know, in looking how to deal with this capture structure, would this could be one of the potential way to go forward to deal with this anti-human rights legislation. So involve other, you know, state level actors. But it sounds huge, right? But let's think about it in some interesting, you know, comparative examples. Maybe let's start with Renata. How to look forward, you know, for paths to deal with those captured human rights systems. Is there any lesson that could be learned by Poland, one day by Hungary as well?
So maybe this is two different tracks, and so let me respond to partly what Ellen said before. Working in the enforcement phase with the discretion the system leaves, because the Hungarian anti-LGBT law was put on the books knowing full well that this is going to violate the convention. By that time, we had the Russian judgment. The Hungarian government could fully well expect that if and when this law is challenged in Strasbourg, the court will find a clear-cut violation. There was also an extremely rapid response already when the bill was pending in Parliament and before it was passed into law from the European Parliament, calling it a retrogression of human rights in clear terms. This was very strong language also from the Commission, warning them that this does not pass European human rights standards. The government adopted this piece of legislation nonetheless. And that is a very, very clear sign that the Hungarian government is not going to be stopped simply by knowing what the European standards are. Rather, they will be happy with this piece of legislation on the books for a number of years. And it took a number of years to get to the hearing in Luxembourg. There is a massive resistance with these member states, but keep in mind that this is the first time, and it's an exceptional case that you have so many member states joining in. At the same time, what we also see that the European Court of Human Rights, of its own part, is becoming very tired of this kind of a monkey business. So let me give you an example on how the European Court of Human Rights is deferring to recalcitrant member states, and Alan will know this case from a previous conference. So from very early on, the Hungarian parliamentary opposition has been successful in protecting opposition protest rights within parliament against punitive sanctions by the Speaker of Parliament. At the time when the first case was brought to Strasbourg, European member states were actually warning the Strasbourg court, saying that, you know, parliamentary autonomy is a very important European value. Many of us uphold it. The last thing you want is judicial interference with parliamentary autonomy. Nonetheless, in Karácsony and France, the Hungarian opposition applicants prevailed. The court said that protecting opposition speech in parliament was crucial to a functioning constitutional democracy. Recently, the European Court of Human Rights changed course on that line of jurisprudence. In a new case, they said that the efficiency of the parliamentary process was much more important than opposition rights. So relying on subsidiarity and judicial deference to the local democratic processes, they actually reversed on a very important guarantee of protecting the plurality of national domestic politics and reinforced majoritarian interpretations of democracy. And you do not really see this case being criticized widely by the same governments which went to protect the Commission in the LGBT rights case. And this has real long-term ramifications on the interpretation of democracy and what is necessary in a democratic society within the ECHR space.
Yeah, if I can just perhaps complement what Renata said. I think for me, since the conversation started here with the rights of sexual minorities, for example, so I think that when it comes to protecting, I would say, the equality and the agency of individuals and the associated rights, so I'm thinking not just of sexual minorities, I'm also thinking of asylum seekers, for example. The court, I think, will easily find violations. So it has, I think, the standards, the equipment to counter this kind of abuse, if you wish. But as Renata pointed out, things are different when it comes to the core institutions of democracy, such as parliament, for example. So when it comes to these institutions, the court is a lot more deferent. And it, of course, invokes subsidiarity and a margin of appreciation. But for example, in the case that, in the two cases that Renata mentioned, the court, for example, did not examine whether the interference with political opposition in parliament was necessary. Okay, so it did not, if you wish, investigate the proportionality of the interference. And that shows that there's, in my view, a lack of scrutiny there when it comes to not just, again, abuse of equality rights and agency rights, but abuse of the procedures and the processes of democracy that are being dismantled within the state. And if I can just try to connect these legal issues with the other perspectives that we've touched upon across the day, so perspective coming from political scientists and political theorists, for me it's really important to draw parallels between the two. So the literature on the political theory of populism shows that populists want to expedite the democratic process. They're impatient with the democratic process. They are not good at it. They want to do away with political inclusion, political deliberation, speaking to the opposition. That actually has an equivalent in how governments defend themselves and argue at the European Court of Human Rights. So these authoritarian or rogue states will have a hard time demonstrating that what they do is necessary, that it pursue a legitimate aim according to the convention. And they fail most of the time to balance rights. So for me, proportionality is an interesting site for observing authoritarian populists and whether the court is actually apt to respond. And again, coming back to the cases cited by Renata, it does not, I think, appropriately respond because it doesn't really examine what these governments are actually trying to achieve when they restrict interferences with human rights. I hope this makes sense.
I mean, that brings another example. That there is a similar Polish case. I think it's still pending. So MP who was fined with some quite big sum because of the protest in 2016 in Parliament. I think that one is still pending. So let's see how the same problem is going to be assessed someday in future. But while you were discussing, you know, these potentials and procedures, I was also thinking about one of the topic which Edith worked on. So let's imagine something that you could think about human rights violation, but in a kind of informal way. How to catch the you don't have, you know, you don't have a fine. You have some sort of informal set of practices which end up in lowering the standard of human rights protection. And I know I mentioned, you know, your past life experience being a journalist, but this is a kind of a broad topic in Hungary, meaning the level of freedom of media, pluralism of media, which in the end might have a direct result in a democratic process, which we discussed in those two cases. Could you elaborate on that a little bit?
Yeah, it has a lot to do with the nature of power in Hungary, which is tremendously informal in many cases. So, like toying with the constitutional majority and undermining and providing new laws to make the life of these people difficult, that's one thing. But the other thing is that there are many other instruments at the disposal of the Hungarian government with which they can do it on a daily basis. And one of them is, as Barbara mentioned, is related to the captured media in Hungary. And this is really the linchpin of the regime durability of Viktor Orbán. So I think we can safely say this. It is helping the government on a daily basis to undermine the legitimacy of this human rights activists, but also the minorities themselves or their rights. And I'm going to quote here the political director of the government. He's also an Orbán, but they're not related with Viktor Orbán, who said once that media is a strategic sector and a matter of sovereignty, because whoever controls the media of a country controls the country itself, therefore the mindset of the people. So they wouldn't even kind of hide that this is their end goal, and that's what they try to do to cement the power. And the way how they do this informally is that very many cases, the media, the mainstream media, and especially the print and the local media in the countryside has been captured by, you know, people who have been informally linked to the prime minister. So the entourage, the allies, business cooperative people who have been buying up media outlets and then turn them over or close them for the will of the government. And end of the day, most of them have been just willingly and deliberately donated to a foundation which is run by the government. So it is the very essence of the nature of informal power centered around the prime minister. There has been actually quite many similar kind of domains with the Polish case here, how PIS was also trying to repolonize the media, naming, blaming, and shaming the foreign investors on the market, but also capturing the regulators. That was very important. It's a very legalistic way of doing things. Capturing the state broadcaster. And I think what's really important here when it comes to informality is the flow of the money. So follow the money. And here the golden rule is he who has the gold rules the mindset of the people. It's very simple. And what both government has actually been doing, and Hungary is still doing it, Fidesz, is to weaponize the state advertisement to tremendous amount of level, which means that 99% of state advertisement in Hungary is being directed to media, which is loyal to the government. What's even further a more informal effect in this is the tremendous chilling effect, which is being imposed on media workers. I'm, as a former journalist, I can confirm that this is exactly how the system works. It's not like people are going to you in the editorial and telling you what exactly to write and what not to do, but you eventually know how to get things done if you would like to keep your job, because this is getting existential at the end of the day. So there is stick and carrot in the system. And the problem is that while we have this complex problem in Hungary, the European Commission has been doing close to little to address this problem. I mean, when it comes to capturing the media and media plurality, only one infringement procedures has been launched against Hungary with regards to a radio, which has lost its license years before the case has been launched. So it was too little, too late. There is this kind of argument very often that the Commission doesn't have competences to do anything when it comes to media. This is not true. If you look at the Hungarian case, it's enough to look at two things. One of them is competition law, the other one is state aid, and both have been violated by the Hungarian government many times. By the way, also I think by the Polish government, the previous one. It has occurred. So this is something where the Commission could have eventually launched more infringement procedures. And also the other problem is that when it comes to how the European Union is currently measuring the democratic functionality of those national authorities that are looking at the functioning of the national media, like media councils, different kind of regulatory bodies. I'm sorry to say, but this is like a joke, technically. So the way how it functions, according to the audiovisual media directive in the European Union, Hungary is doing fine. I mean, our media council is just doing everything according to the book. It has a very nice, transparent budget, and everything is at the website. And there is no kind of formally there is no kind of problem with it. But when it comes to the decision that this body is making, it's obviously very biased and allowing different kind of media merges and different kind of media purchases, which are helping the government in power in order to maintain its power. And it is not being addressed at all. So I think what would need to be done by the European Commission is to figure out how to measure better the democratic functionality of these bodies, because if we don't do this, how are we going to expect that we will have a clear picture about what's going on in the member states? And it's a slippery slope because we see what's happening in Spain and Greece. This is not only a problem in Hungary, this might be a problem elsewhere, because other populist governments might take notes of how to get things done easily. So I think that would be important to take into account.
Thank you. The footnote for the audience, you can prepare your questions, but I still want to ask additional one, since many issues were mentioned by you. So I think Renata mentioned the issue of time. So, or you, Alan, that destroying democracy and human rights system, it is a function of time. So then rebuilding the system or putting it back to shape, it's also, I think, a function of time. And you heard today in the first panel that the issue of time is something extra, important, at least for people in the ministry, but also I think for the electorate. So we want fast reactions, fast rebuilding of the institutions, and we know it's not how it works. It's not going to work like that. But at the same time, when I'm thinking about the international and supranational human rights systems, there is an issue discussed in the literature which is called mobilization. So if you want to somehow protect or rebuild your human rights system, you have to go, to Strasbourg, you have to go to Luxembourg to ask, for protection. And of course, capturing judicial system is one of the main signs why the domestic system, how the domestic system could be abused, could be captured. And one of the questions which I'm getting most of the time is a question, let's compare, Hungarian and Polish judges, why the Polish judges ask so many preliminary references to the Court of Luxembourg and Hungarians didn't do that. And one of the answers from the Hungarian judges is it was a kind of a salami method. So, it was like changing piece by piece, and not the Polish piece, slide by slide. And you cannot see then the damage, the difference between the independence judiciary and an institution which is totally captured. So I'm wondering, on one hand, this is a question to Alan, how it is, whether the Strasbourg has tools, to deal with those different, difficult kind of, gray areas of assessing the situation, for instance, of a judiciary, since one of the main part of the rule of law case law recently in Strasbourg court deals exactly with judicial independence and cases dealing exactly with judicial independence. But the same question would go to Renata as well.
Yeah, I think the element of time, if it is problematic in the EU context and the responsiveness of the European Commission, then it's going to be far worse in the context of the Strasbourg court. But we have to remember why that is the case. It's the case because, again, it's a system that really, really depends on the active and good faith contributions of states. The court is only a supervisory organ, technically. It only declares whether there has been violations of the convention or not. So how is this problem of time happening in the case of typically the dismantling of the judicial system? The problem is that, in fact, there are two instances where the Strasbourg court can intervene. For example, at the admissibility stage. So if you think as an applicant and as a potential victim that it's not just that you had a human rights violation, that you were the victim of a human rights violation, but you also think that there's no remedy system within your state, typically when you have apex courts that have been captured, then the court could potentially respond to that argument and say, okay, in that case, we are going to lift the exhaustion of domestic remedies. And that would be, time-wise, much better. But what are the consequences of that shift? Well, basically, the Strasbourg court becomes a court of first instance. And you will have an explosion of cases and a case management problem along the way. So that's why I think the Strasbourg court again, has been quite reluctant to do so and to place a pretty high burden of proof on the applicant to demonstrate that there is systemic issues within this or that state. And of course, the other instance where the court could intervene is at the merit stage, and it could get into, I would say, the specifics of a structural deficiency within the state, and it has done so, but that takes a lot longer. Okay, so again, when I look at how responsive the European Court of Human Rights is, we have to remember that it doesn't have the same tools as the European Union or Court of Justice of the EU. It doesn't have a procedure to essentially have control over the purse, to use this metaphor. So that's something important to keep in mind.
Yeah, so you have judicial and political time, and the rule of law definitely does take time because of exhaustion of domestic remedies. So to bring those two cases from Hungary, where the Strasbourg court decided very, very rapidly and essentially acted as a court of first instance. One was the Baka case, the dismissal of the Chief Justice of the Supreme Court through constitutional reform, and then the other was the church law case. In both cases, Strasbourg acted so fast because there were no domestic remedies in the system. What the Hungarian regime learned, and others made sure they will follow, is that they provide ample opportunities for domestic remedies, which then have to be exhausted. Now, in terms of time and illiberal and autocratic rulers, let me bring two non-European examples. Just compare the judicial responses to the election interference by Trump and Bolsonaro. Essentially, the cases against Trump managed to be pending in court for so long that the federal cases were just thrown out after his re-election this week. While in Brazil, Bolsonaro has been banned from returning to elected office till 2030 through the electoral justice system shortly after the elections. Now compare that to the fact that the federal police actually released its comprehensive report on Bolsonaro's election interference attempts, including coup attempts and assassination plans against the election judge who later banned him from office earlier this month. Right? So there was very rapid judicial time in electoral justice cases in Brazil. There was the investigative time with a rule of law compliant police investigation, which took a number of years. and then you have political time. And I guess that in the Polish case, when it comes to restoring the rule of law and frankly future-proofing the judiciary from similar attacks in the future, the question is not simply the judicially sensible timing of some of the measures, but also the sensible political timing. What you can see is that the Venice Commission is much more sensitive to timing of measures locally and responses locally than the ECHR. For the ECHR, time is a very, very sore spot. They would have never ended up with Brighton had they not been taking 12 years with deciding cases in the first instance. And what you will look at with the Venice Commission is that the Venice Commission is really interested in the inclusiveness of the political processes that produce the types of reforms which will unsettle the status quo within the judiciary and which are likely to be divisive locally. Now, these processes do take time because any kind of participatory mechanism does take a fair bit of time, and this is when it does matter whether you put the measure in terms of restoring the rule of law, which will sound to some people as revenge politics through judicial reform, or use the German terminology which has been used recently in building the resilience of the judiciary from future illiberal attacks, which is the rhetoric currently used for German rule of law reforms, even if building this resilience requires making concessions in the course of this dialogue. If you manage to make concessions to keep players in the course of these participatory processes which prepare the legislation for reclaiming the judiciary, you stand a much better chance of being able to show that some of the reforms were, no matter how much they unsettled certain judges or affected certain measures, were necessary not only to restore the judiciary or to restore a status quo, but to improve the resilience of the judiciary in the long run from future similar takeover attacks.
I think we can open the floor to questions. Different examples were presented and discussed. We saw examples from Strasbourg, but also from Luxembourg, and we saw different jurisdictions as a case study. So please, the floor is yours. Just introduce yourselves and please do ask question. Krzysztof, you're the first.
Yeah, so I have a question. Now I can. I wasn't allowed, or I haven't allowed myself to ask the question earlier.
But it's not for the previous panel, right?
No, don't worry. But it's kind of connected, actually. I mean, let's get out a bit of Strasbourg and Luxembourg and try to see it more from the down-to-earth perspective. Specifically in terms of the first part of title of the presentation of the panel is how the populists are using or exploiting the system of protecting the human rights. And I'm referring specifically in something that is also happening in social media, but like in terms of the whole discussion, that I feel like I'm a censor, actually. So I'm referring to the thing that a lot of populist people who actually mostly use hate speech, or they allowed to use the hate speech, they are referring to the freedom of expression, the freedom of speech. I think the question is now is like, what kind of advice in terms of the narratives the liberal Democrats, as us, or at least me, should use in terms to regain the language, this language of human rights, again, because for them, I'm in certain circumstances, of course, when I try to protect minorities or other people from being targeted with the hate speech, the other part of the public discourse, again, using this value as freedom of speech, which I am against. So that's I hope I was clear. That's another question. Here.
I don't mean to abuse the right of the organizers in asking questions. I have a follow-up question to what was already said. This relation between populists and the international institutions and the human rights protection international systems, we put the question in a much more confrontational way, saying that there's a lot of tension between those populistic attempts and this international order. But I wanted to ask you about the different dynamics. What about the situation when the populists actually learn how to use those international mechanisms in a less confrontational way, but rather to hijack the system as such? And here I would like to ask specifically about what happened with the discussion about the migration at the EU level, that over the last 10 years drifted far away from the human rights-oriented standards or the Geneva Convention-derived standards and became much, much populistic in the sense not only of the policies that are being designed, but also the narration around that. So I hope my question is clear. So how about we reverse the dynamic where we actually invite the populists to come here and feel welcome and at home?
Thank you. Here, right? Or no? Yeah.
I have a comment to make about what has been said about the court, which refers to the question that Barbara asked, namely how we can, as Democrats or liberals, go against the grain and actually use the court for the purpose of for our purposes. And I would also like to tie it into the discussion that we had in the morning regarding Plan B. Is there any Plan B concerning Poland? And I think that the part of Plan B regarding Poland would be actually to check, to establish how Polish courts are using these Strasbourg standards. What is the actual case law of the Polish courts regarding Strasbourg situations? Are the courts willing and able and use those standards? And if they use them, in what kind of way they use it? I think it is a significant question because it is striking for Poland that after 30 years of the convention being the part of the land, we have no clear picture of how actually the courts use the Strasbourg standards. We have had this discussion about the control of constitutionality by Polish courts as a sort of weapon against populism during the last 8 years. But the funny thing that didn't happen was that we actually don't know how they use the Strasbourg standards. Either because it is a huge task, academic task, to establish how the Strasbourg court, how the Polish courts refers to the Strasbourg case law, or because for some reasons it's not interesting, or because what? And the other remark I wanted to make is on what happened regarding the picture that the Strasbourg court has in the Polish legal discourse. And I think that what has happened in the last 8 years was that with the best intentions in the world, the Strasbourg court is, in the eyes of general legal public and legal practitioners, advocates and legal counsel, sort of, it became even more far away court, 1,300 kilometers from here, which has nothing to do with normal day-to-day run-of-the-mill legal practice. It happened because the judges sort of, I don't want to be unkind, but they sort of walk up to Strasbourg when they start to be personally threatened by the political regime. Before that, the Polish judges were not champions of referring to the Strasbourg standards in their case law, and this is something about which I hold a grudge against the Polish judiciary. So the good thing would be to check actually what is happening before the courts regarding application of Polish standards and of Strasbourg standards, and also fight a little bit against this exotic, faraway, unimportant court which does not affect the lives of ordinary citizens and ordinary lawyers, ordinary practicing lawyers.
Thank you. Yeah, one more.
Good evening. I'm coming from an international organization myself. My name is Rine Vankiv and I work at ODIHR. I would like to ask a question that I'm not sure we can find an answer, but I still want to ask it. So the title of the panel is how populists use the system of human rights defense and international institutions to realize their own goals. And I think it's important to mention that actually international institutions and the international courts are part of this international system where only states have a standing, basically, and only states have full, agency. So as long as populist governments continue to be elected, the populists are elected to the government, it's fair to assume that the populistic agenda will be appearing more and more in international institutions. And of course, international courts and tribunals are a bit more protected from government's influence, but still governments are the only subjects to public international law that actually creates all these institutions. So my question is there any chance or are there any discussions in academia maybe to give more agency to other subjects other than states to formulate the agenda for international institutions like European Court of Human Rights or any other institutions, UN, OSCE for that matter. I'm not sure if this was the subject of the panel, but I just think that we have to remember that unless we solve this issue of states being the only subjects of international law and them creating the institutions, we won't be able to answer how we can protect this international human rights defense system from actually populistic governments. Thank you.
Thank you. I think we could go with those questions. Maybe let's start with Edith. I think we could pick the best ones and answer them. And yeah.
Thanks. I'll do some cherry picking here. Thanks. I think I'll start with the question of Gosha about how populists are successfully abusing the international order or like organizations in this regard when it comes to migration. Again, from the political point of view, no legalistic kind of aspect here. I leave it to the expert to my right. I think where Viktor Orban is on a discursive level is super successful is that given that he's been the first who's been stepping up against refugees and telling that the ideal number of refugees coming to Hungary is 0, and how eventually the European Union has came to this conclusion that we would effectively need to strengthen the external borders and so on and so forth, became more conservative in this regard. I think he's successfully using it on a daily basis, claiming that, look, Europe is following me and the turf that I have been, the pathways that I was particularly sailing towards from the very beginning. When it comes to national consultations, all the propaganda would somehow relate to this. When it comes to Krzyszak's question about hate speech and how to combat it, or what kind of recommendations shall we give to democratic forces what to do about it, or at least this is how I'm going to interpret the question. It gives me the opportunity to talk a little bit about our new opposition, which grown up to become the single challenger of Viktor Orban in 2026. What I would definitely not recommend for them is to fight fire with fire, because this is not a good idea, but this is what we have been witnessing in the first couple of months, that the new leader of the opposition, this TISA party and its leader, have been employing a quite similar rhetoric when it comes to exclusionary populism. Maybe Renata can challenge me on this, but I'm pretty sure that we agree on this. Very often they're, I would say, quite aggressive when it comes to civil society organizations and journalists. And I think this is particularly dangerous because while he can somehow, show himself that he's the hammer, he's the one who can eventually challenge the government, and he's tough enough to stand up to Viktor Orban, at the same time he's alienating a lot of people and at the same time further polarizing and deepening division within the society. So no fighting fire with fire, and instead of that, I think they should rather try to establish some sort of a reconciliatory different type of political culture, which is about opening up the debate and not excluding different kind of different type of strata of the society, but having them including into the conversation about how to build a new, a new Hungary, technically, from scratch. From the legalistic perspective, I don't want to go into that because this is not my turf. But that's definitely two things that would need to be keep an eye on for them. Is the institutional forbearance. So no matter what kind of constitutional or non-constitutional majority they will have, they would need to be smart with how to try to redemocratize the country in a very democratic way. And I think in this perspective, Poland could be a very interesting lesson learned for the Hungarian opposition. And the other one is the mutual tolerance, which is linked to my first point, to not to exclude anyone.
To hit some of my favorite points here, and starting with the international human rights system and how it became a staging ground for illiberal forces. Again, this is not us. If you remember Muslim states' efforts to combat Islamophobia and the defamation of religions, that is when various fora of the UN became the promotion grounds for very religious, very conservative agenda items, first on the fringes, then in the UN Human Rights Council, and then they got consolidated into the terminology of how we go, how a much more conservative, non-human rights-based, religion-based language is actually acceptable in these fora. So when it came to the global migration crisis, this is when we start to deal with the persecution of Christians as a human rights topic. And so that takes me to the second point, which is we do prioritize the ECHR as the main site for defending human rights. It's actually one of the many sites in the international systems. There was a fair bit of money and effort by the American conservative legal movement to promote strategic litigation before the ECHR for a better part of two decades before we got to the point where discretion opened up quite the way Alan was describing it. But we shouldn't forget that actually the ECHR for the most part it's not the only site, but most of the time, because of the time lag, it's not the leading light on setting standards. In the judicial independence cases, the ECHR was following the Venice Commission and the Court of Justice for the most part. BACA was the exception because of lack of domestic remedies. In most of the other cases, the ECHR steps in the latest, so any intervention you do has to be in front of other fora. And with the exception of the Polish judicial independence cases, and especially with Wałęsa, the ECHR judgments are actually just giving a piece of the puzzle. They don't give you a consolidated record. They don't give you a tour de force. Outside Article 18, the ECHR doesn't do any job at all to establish a pattern of abuse of powers. Much of that work was actually done outside judicial independence by the European Parliament in its resolutions through parliamentary inquiry. This is why it is so important that you have this major leap of the right in obtaining robust representation before the European Parliament, because they will be able to undermine parliamentary inquiries into rule of law issues. They will be able to litter the record and slow down the type of consolidation work that parliamentary scrutiny was doing before the last parliament, which is essential for maintaining the type of narrative pressure that the Commission needs and that both the Luxembourg court needs and the Strasbourg court needs in order to respond to illiberal challenges. Now, on reclaiming the language and Krzysztof, let me take you to Aisha Berlin, because Berlin made it very clear that freedom has nothing to do genuinely with democracy. We make the connection and we define the freedom from and the freedom to in terms of living in a democracy through actively identifying the goods we are after and also the fear and the wrong that we try to use the language of freedom against. Now, this is where reclaiming free speech comes from. It's not, unless if you manage to link it back to the origins of what freedom of speech is for in a democracy, you will never win this game. And Alan knows this argument of mine, which is a pet argument, that I do believe that the European human rights system is underpinned by a commitment to furthering human rights, which includes, that's in the preamble of the convention, which includes a very clear obligation of not walking rights back, a very clear obligation of non-retrogression in civil and political rights as well. This is an argument that we tried in an intervention in Makate with the Hattir LGBT NGO to show that there is a positive obligation not to do wrong and not to roll rights back. And I would like to see more work on this front, because otherwise it's going to be extremely difficult to explain what's wrong with the populist and liberal takes on reinterpreting religion, assembly, freedom of speech rights on the ground.
Yeah, so I think I would only have maybe a response or a comment on the question of hate speech. So I don't want to sound like an ardent defender of the Strasbourg Court, but I think that the Strasbourg Court at least has developed an ethic of democratic discourse. And I would see two dimensions to this discourse. I would say that there's a very liberal aspect. So that means that if you want to express a view that is going to sound insulting, that can be perceived as offensive, if you are engaging in quite critical and political satire, for example, usually this is something that the court will pay very much attention to. And that's the liberal aspect. But there's also a deliberative aspect to the court's ethic of democratic discourse, which is that you will be able to be more critical, to be more offensive, provided that there's a response being given by the person that you are attacking or that you are critiquing. So there's a right to response, for example, under Article 10 of the European Convention on Human Rights. And my sense is that if maybe that's just a kind of a hypothesis, but it seems to me that governments and public authorities in Europe have only taken the liberal but not the deliberative aspect of that democratic ethic. There's also maybe a third element that might matter here in terms of how not just discourse and political discussion is taking place, but a connection to what Edith has been highlighting, which is the role of the media. And I think that's not maybe the liberal dimension of free speech, but the neoliberal dimension of free speech, in the sense that the court is not yet at the stage where it's going to scrutinize exactly how the media system is operating within a state party, or within how the government might be actually having the upper hand on the organization of the media system. So this kind of infrastructural dimension of democratic discourse is something that is out of sight for the Strasbourg Court. So that's again a point of vulnerability, I think, that we need to address as scholars, and to try to connect the dots between democratic discussion and the right of everyone to engage and to participate in democratic discussion, even on very liberal terms, but at the same time looking at the preconditions and looking at the media infrastructure, I think, is something that the court should do more.
It seems we managed the impossible, so we finished at 5. Thank you a lot to the participants, to the panelists. Thank you for joining us today and for answering my, but also audience question. This is all for today for the conference. We get back tomorrow at 9:30, the same place, the same coffee break. So thank you for your attention. and see you tomorrow. Thank you.